Hello, everyone. Today's case is Citizens United versus Federal Election Commission. So this is a very controversial one from 2010. So this is regarding political contributions and who can and bans like that. So, as amended by subsection 203 of the Bipartisan Campaign Reform Act of 2002, BCRA, federal law prohibits corporations and unions from using their general treasury funds to make independent expenditures for speech that is an electioneering communication or for speech that expressly advocates for the election or defeat of a candidate. An electioneering communication is any broadcast, cable, or satellite communication that refers to a clearly identified candidate for federal office and is made within 30 days of a primary election, and that is publicly distributed, which in the case of a candidate for nomination for president means that the communication can be received by 50,000 or more persons in a state where a primary election is being held within 30 days. Corporations and unions may establish a political action committee, PAC, for express advocacy or electioneering communications purposes. In McConnell versus Federal Election Commission, this court upheld limits on electioneering communications in a facial challenge, relying on the holding in Austin v. Michigan Chamber of Commerce that political speech may be banned based on the speaker's corporate identity. In January 2008, Appellant Citizens United, a nonprofit corporation, released a documentary, Hereinafter Hillary, critical of then-Senator Hillary Clinton, a candidate for her party's presidential nomination. Anticipating that it would make Hillary available on cable television through video on demand within 30 days of primary elections, Citizens United produced television ads to run on broadcast and cable television. Concerned about possible civil and criminal penalties for violating subsection 441B, it sought declaratory and injunctive relief, arguing that 1. Subsection 441B is unconstitutional as applied to Hillary, and 2. BCRA's disclaimer, disclosure, and reporting requirements, BCRA subsections 201 and 311, were unconstitutional as applied to Hillary and the ads. The district court denied Citizens United a preliminary injunction and granted appellee Federal Election Commission, FEC, summary judgment. Held. Because the question of whether subsection 441B applies to Hillary cannot be resolved on other narrower grounds without chilling political speech, this court must consider the continuing effect of the speech suppression upheld in Austin. Citizens United's narrower arguments that Hillary is not an electioneering communication covered by subsection 441B because it is not publicly distributed under 11 CFR subsection 100.29A2, that subsection 441B may not be applied to Hillary under Federal Election Commission versus Wisconsin Right to Life Incorporated, which found subsection 441B unconstitutional as applied to speech that was not express advocacy or its fundamental equivalent. Determining that a communication is the functional equivalent of express advocacy only if it is susceptible to no reasonable interpretation other than as an appeal to vote for or against a specific candidate. That subsection 441B should be invalidated as applied to movies shown through video on demand because this delivery system has a lower risk of distorting the political process than do television ads, and that there should be an exception to subsection 441B's ban for nonprofit corporate political speech, funded overwhelmingly by individuals, are not sustainable under a fair reading of the statute. Thus, this case cannot be resolved on a narrower ground without chilling political speech that is central to the First Amendment's meaning and purpose. Citizens United did not waive this challenge to Austin when it stipulated to dismissing the facial challenge below, since 1. Even if such a challenge could be waived, this court may reconsider Austin and subsection 441B's facial validity here because the district court passed upon the issue. Whoops, lost my spot. Citing that. Throughout the litigation, Citizens United has asserted the claim that the FEC has violated its right to free speech, and 3. The parties cannot enter into a stipulation that prevents the court from considering remedies necessary to resolve a claim that has been preserved. Because Citizens United's narrower arguments are not sustainable, this court must, in an exercise of its judicial responsibility, consider subsection 441B's facial validity. Any other course would prolong the substantial nationwide chilling effect caused by subsection 441B's corporate expenditure ban. This conclusion is further supported by the following. 1. The uncertainty caused by the government's litigating position. 2. Substantial time would be required to clarify subsection 441B's application on the point raised by the government's position in order to avoid any chilling effect caused by an improper interpretation. And 3. Because speech itself is of primary importance to the integrity of the election process, any speech arguably within the reach of rules created for regulating political speech is chilled. The regulatory scheme at issue may not be a prior restraint in the strict sense. However, given its complexity and the deference courts show to administrative determinations, a speaker wishing to avoid criminal liability threats, and the heavy costs of defending against FEC enforcement must ask a governmental agency for prior permission to speak. The restriction thus functions as the equivalent of a prior restraint, giving the FEC power analogous to the type of government practices that the First Amendment was drawn to prohibit. The ongoing chill on speech makes it necessary to invoke the earlier precedents that a statute that chills speech can and must be invalidated where its facial invalidity has been demonstrated. 2. Austin is overruled, and thus provides no basis for allowing the government to limit corporate independent expenditures. Hence, subsection 441B's restrictions on such expenditures are invalid and cannot be applied to Hillary. Given this conclusion, the part of McConnell that upheld BCRA's subsection 203's extension of subsection 441B's restrictions on independent corporate expenditures is also overruled. A. Although the First Amendment provides that Congress shall make no law abridging the freedom of speech, subsection 441B's prohibition on corporate independent expenditures is an outright ban on speech, backed by criminal sanctions. It is a ban notwithstanding the fact that a PAC created by a corporation can still speak, for a PAC is a separate association from the corporation. Because speech is an essential mechanism of democracy, it is the means to hold officials accountable to the people. Political speech must prevail against laws that would suppress it by design or inadvertence. Laws burdening such speech are subject to strict scrutiny, which require the government to prove that the restrictions further a compelling interest and is narrowly tailored to achieve that interest. This language provides a sufficient framework for protecting the interests in this case. Premised on mistrust of governmental power, the First Amendment stands against attempts to disfavor certain subjects or viewpoints or to distinguish among different speakers, which may be a means to control content. The government may also commit a constitutional wrong when, by law, it identifies certain preferred speakers. There is no basis for the proposition that, in the political speech context, the government may impose restrictions on certain disfavored speakers. Both history and logic lead to this conclusion. The court has recognized that the First Amendment applies to corporations and extended this protection to the context of political speech, addressing challenges to the Federal Election Campaign Act of 1971. The court in Buckley v. Vallejo upheld limits on direct contributions to candidates, recognizing a governmental interest in preventing quid pro quo corruption. However, the court invalidated subsection 608E's expenditure ban, which applied to individuals, corporations, and unions because it failed to serve any substantial government interest in stemming the reality or appearance of corruption in the electoral process. While Buckley did not consider a separate ban on corporate and union independent expenditures found in subsection 610, had the provision been challenged in Buckley's wake, it could not have been squared with the precedent's reasoning and analysis. The Buckley court did not invoke the overbreadth doctrine to suggest that subsection 608E's expenditure ban would have been constitutional had it applied to corporations and unions but not individuals. Notwithstanding this precedent, Congress soon recodified subsection 610's corporate and union expenditure ban at 2 U.S.C. subsection 441B. The provision at issue. Less than 2 years after Buckley, Bellotti reaffirmed the First Amendment principle that the government lacks the power to restrict political speech based on the speaker's corporate identity. Thus, the law stood until Austin upheld a corporate independent expenditure restriction, bypassing Buckley and Bellotti by recognizing a new governmental interest in preventing the corrosive and distorting effects of immense aggregations of corporate wealth that have little to or no correlation to the public's support for the corporation's political ideas. This court is confronted with conflicting lines of precedent, a pre-Austin line forbidding speech restrictions based on the speaker's corporate identity and a post-Austin line permitting them. Neither Austin's anti-distortion rationale nor the government's other justifications support subsection 441B's restrictions. 1. The First Amendment prohibits Congress from fining or jailing citizens or associations of citizens for engaging in political speech, but Austin's anti-distortion rationale would permit the government to ban political speech because the speaker is an association with with a corporate form. Political speech is indispensable to decision-making in a democracy, and this is no less true because the speech comes from a corporation. This protection is inconsistent with Austin's rationale, which is meant to prevent corporations from obtaining an unfair advantage in the political marketplace by using resources amassed in the economic marketplace. First Amendment protections do not depend on the speaker's financial ability to engage in public discussion. These conclusions were reaffirmed when the court invalidated a BCRA provision that increased the cap on contributions to one candidate if the opponent made certain expenditures from personal funds. Distinguishing wealthy individuals from corporations based on the latter's special advantages of, for example, limited liability does not suffice to allow laws prohibiting speech. It is irrelevant for First Amendment purposes that corporate funds may have little or no correlation to the public's support for the corporation's political ideas. All speakers, including individuals and the media, use money amassed from the economic marketplace to fund their speech, and the First Amendment protects the resulting speech. Under the anti-distortion rationale, Congress could also ban political speech of media corporations. Although currently exempt from subsection 441B, they accumulate wealth with the help of their corporate form, may have aggregations of wealth, and may express views having little or no correlation to the public's support for those views. Differential treatment of media corporations and other corporations cannot be squared with the First Amendment, and there is no support for the view that the amendment's original meaning would permit suppressing media corporations' political speech. Austin interferes with the open marketplace of ideas protected by the First Amendment. Its censorship is vast in its reach, suppressing the speech of both for-profit and non-profit, both small and large corporations. This reasoning also shows the invalidity of the government's other arguments. It reasons that corporate political speech can be banned to prevent corruption or its appearance. The Buckley Court found this rationale sufficiently important to allow contribution limits, but refused to extend that reasoning to expenditure limits. And the court does not do so here. While a single Bilotti footnote purported to leave the question open, this court now concludes that independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption. That speakers may have influence over or access to elected officials does not mean that those officials are corrupt, and the appearance of influence or access will not cause the electorate to lose faith in this democracy. The government's asserted interest in protecting shareholders from being compelled to fund corporate speech, like the anti-distortion rationale, will allow the government to ban speech even of media corporations. The statute is under-inclusive. It only protects a dissenting shareholder's interest in a certain media for 30 or 60 days before an election when such interest would be implicated in any media at any time. It is also over-inclusive because it covers all corporations, including those with one shareholder. Because subsection 441B is not limited to corporations or associations created in foreign countries or funded predominantly by foreign shareholders, it would be overbroad even if the court were to recognize a compelling governmental interest in limiting foreign influence over the nation's political process. The relevant factors in deciding whether to adhere to stare decisis beyond workability, the precedent's antiquity, the reliance interests at stake, and whether the decision was well-reasoned. Counsel in favor of abandoning Austin, which itself contravened the precedents of Buckley and Bilotti. As already explained, Austin was not well-reasoned. It is also undermined by experience since its announcement. Political speech is so ingrained in this country's culture that speakers find ways around campaign finance laws. Rapid changes in technology and the creative dynamic inherent in the concept of free expression counsel against upholding a law that restricts political speech in certain media or by certain speakers. In addition, no serious reliance issues are at stake. Thus, due consideration leads to the conclusion that Austin should be overruled. The court returns to the principle established in Buckley and Bilotti, that the government may not suppress political speech based on the speaker's corporate identity. No sufficient governmental interest justifies limits on the political speech of nonprofit or for-profit corporations. 3. BCRA subsections 201 and 311 are valid as applied to the ads for Hillary and to the movie itself. A. Disclaimer and disclosure requirements may burden the ability to speak, but they impose no ceiling on campaign-related activities. The Buckley Court explained that disclosure can be justified by governmental interest in providing the electorate with information about election-related spending sources. The McConnell Court applied this interest in rejecting facial challenges to subsections 201 and 311. However, the court acknowledged that as-applied challenges would be available if a group could show a reasonable probability that disclosing its contributors' names would subject them to threats, harassment, or reprisal from either government officials or private parties. B. The disclaimer and disclosure requirements are valid as applied to Citizens United's ads. They fall within BCRA's electioneering communication definition. They referred to then Senator Clinton by name shortly before a primary and contained pejorative references to her candidacy. Section 311 disclaimers provide information to the electorate and ensure that the voters are fully informed about who is speaking. At the very least, they avoid confusion by making clear that the ads are not funded by a candidate or party or political party. Citizens United arguments that subsection 311 is under-inclusive because it requires disclaimers for broadcast advertisements but not for print or internet advertisement, and that subsection 311 decreases the quantity and effectiveness of the group's speech were rejected in McConnell. This court also rejected their contention that subsection 201's disclosure requirements must be confined to speech that is the functional equivalent of express advocacy under WRTL's Wisconsin Right to Life's test for restrictions on independent expenditures. Disclosure is the less restrictive alternative to more comprehensive speech regulations. Such requirements have been upheld in Buckley and McConnell. Citizens United's argument that no informational interest justifies applying subsection 201 to its ads is similar to the argument this court rejected with regard to disclaimers. Citizens United finally claims that disclosure requirements can chill donations by exposing donors to retaliation, but offers no evidence that its members face the type of threats, harassment, or reprisal that might make subsection 201 unconstitutional as applied. For these same reasons, this court affirms the application of the subsections 201 and 311 disclaimer and disclosure requirements to Hillary. Reversed in part, affirmed in part, and remanded. Okay, Justice Kennedy delivered the opinion of the court in which Roberts, Scalia, Alito joined, in which Thomas joined as to all but part 4, in which Stevens, Ginsburg, Breyer, and Sotomayor joined as to parts 4. Roberts filed a concurring opinion in which Alito joined. Scalia filed a concurring opinion in which Alito joined, and in which Thomas joined in part. Stevens filed an opinion concurring in part and dissenting in part, in which Ginsburg, Breyer, and Sotomayor joined. Thomas filed an opinion concurring in part and dissenting in part. Justice Kennedy delivered the opinion of the court. Federal law prohibits corporations and unions from using their general treasury funds to make independent expenditures for speech defined as an electioneering communication, or for speech expressly advocating the election or defeat of a candidate. Limits on electioneering communications were upheld in McConnell v. Federal Election Commission. The holding of McConnell rested to a large extent on an earlier case, Austin v. Michigan Chamber of Commerce. Austin had held that political speech may be banned based on the speaker's corporate identity. In this case, we are asked to reconsider Austin and, in effect, McConnell. It has been noted that Austin was a significant departure from ancient First Amendment principles. We agree with that conclusion and hold that stare decisis does not compel the continued acceptance of Austin. The government may regulate corporate political speech through disclaimer and disclosure requirements, but it may not suppress that speech altogether. We turn to the case before us. Citizens United is a nonprofit corporation. It brought this action in the United States District Court for the District of Columbia. A 3-judge court later convened to hear the cause. The resulting judgment gives rise to this appeal. Citizens United has an annual budget of about $12 million. Most of its funds are from donations by individuals, but in addition, it accepts a small portion of its funds from for-profit corporations. In January 2008, Citizens United released a film entitled Hillary the Movie. We refer to the film as Hillary. It is a 90-minute documentary about then-Senator Hillary Clinton, who was a candidate in the Democratic Party's 2008 presidential primary elections. Hillary mentions Senator Clinton by name and depicts interviews with political commentators and other persons, most of them quite critical of Senator Clinton. Hillary was released in theaters and on DVD, but Citizens United wanted to increase distribution by making it available through video on demand. Video on demand allows digital cable subscribers to select programming from various menus, including movies, television shows, sports, news, and music. The viewer can watch the program at any time and can elect to rewind or pause the program. In December 2007, a cable company offered for a payment of $1.2 million to make Hillary available on a video-on-demand channel called Elections '08. Some video-on-demand services require viewers to pay a small fee to view a selected program, but here the proposal was to make Hillary available to viewers free of charge. To implement the proposal, Citizens United was prepared to pay for the video on demand and to promote the film. It produced 2 10-second ads and 1 30-second ad for Hillary. Each ad includes a short and, in our view, pejorative statement about Senator Clinton, followed by the name of the movie and the movie's website address. Citizens United desired to promote the video on demand offering by running advertisements on broadcast and cable television. Before the Bipartisan Campaign Reform Act of 2002, the BCRA, federal law prohibited and still does prohibit corporations and unions from using general treasury funds to make direct contributions to candidates or independent expenditures that expressly advocate the election or defeat of a candidate through any form of media in connection with certain qualified federal elections. BCRA subsection 203 amended subsection 441B to prohibit any electioneering communication as well. An electioneering communication is defined as any broadcast, cable, or satellite communication that refers to a clearly identified candidate for federal office and is made within 30 days of a primary or 60 days of a general election. The Federal Elections Commission's regulations further define an electioneering communication as a communication that is publicly distributed. In the case of a candidate for a nomination for president, publicly distributed means that the communication can be received by 50,000 or more persons in a state where a primary election is being held within 30 days. Corporations and unions are barred from using their general treasury funds for expressed advocacy or electioneering communications. They may establish, however, a separate segregated fund known as a Political Action Committee or PAC for these purposes. The monies received by the segregated fund are limited to donations from stockholders and employees of the corporation or, in the case of unions, members of the union. Citizens United wanted to make Hillary available through video on demand within 30 days of the 2008 primary elections. It feared, however, that both the film and the ads would be covered by subsection 441B's ban on corporate-funded independent expenditures, thus subjecting the corporation to civil and criminal penalties under subsection 437G. In December 2007, Citizens United sought declaratory and injunctive relief against the FEC. It argued that 1. Subsection 441B is unconstitutional as applied to Hillary, and 2. BCRA's disclaimer and disclosure requirements, BCRA subsections 201 and 311, are unconstitutional as applied to Hillary and to the 3 ads for the movie. The district court denied Citizens United's motion for a preliminary injunction and then granted the FEC's motion for summary judgment. The court held that subsection 441B was facially unconstitutional under McConnell and that subsection 441B was constitutional as applied to Hillary because it was susceptible of no other interpretation than to inform the electorate that Senator Clinton is unfit for office, that the United States would be a dangerous place in a President Hillary Clinton world, and that viewers should vote against her. The court also rejected Citizens United's challenge to BCRA's disclaimer and disclosure requirements. It noted that the Supreme Court has written approvingly of disclosure provisions triggered by political speech, even though the speech itself was constitutionally protected under the First Amendment. We noted probable jurisdiction. The case was re-argued in this court after the court asked the parties to file supplemental briefs addressing whether we should overrule either of both Austin and the part of McConnell in which addresses the facial validity of 2 U.S.C. subsection 441B. Before considering whether Austin should be overruled, we first address whether Citizens United's claim that subsection 441B cannot be applied to Hillary may be resolved on other narrower grounds. Citizens United contends that subsection 441B does not cover Hillary as a matter of statutory interpretation because the film does not qualify as an electioneering communication. Citizens United raises this issue for the first time before us, but we consider the issue because it was addressed by the court below. Under the definition of electioneering communication, the video-on-demand showing of Hillary on cable television would have been a cable communication that referred to a clearly identified candidate for federal office, and that was made within 30 days of a primary election. Citizens United, however, argues that Hillary was not publicly distributed because a single video-on-demand transmission is sent only to a requesting cable converter box, and each separate transmission, in most instances, will be seen by just one household, not 50,000 or more persons. This argument ignores the regulation's instruction on how to determine whether a cable transmission can be received by 50,000 or more persons. The regulation provides that the number of people who can receive a cable transmission is determined by the number of cable subscribers in the relevant area. Here, Citizens United wanted to use a cable video on demand system that had 34.5 million subscribers nationwide. Thus, Hillary could have been received by 50,000 persons or more. One amici brief asks us, alternatively, to construe the condition that the communication can be received by 50,000 or more persons to require a plausible likelihood that the communication will be viewed by 50,000 or more potential voters, as opposed to requiring only that the communication is technologically capable of being seen by that many people. Whether the population and demographic statistics in a proposed viewing area consisted of 50,000 registered voters but not infants, preteens, or otherwise electorally ineligible recipients would be a required determination subject to judicial challenge and review, and in any case where the issue was in doubt. In our view, the statute cannot be saved by limiting the reach of 2 U.S.C. subsection 441b through this suggested interpretation. In addition to the costs and burdens of litigation, this result would require a calculation as to the number of people a particular communication is likely to reach, with an inaccurate estimate potentially subjecting the speaker to criminal sanctions. The First Amendment does not permit laws that force speakers to retain a campaign finance attorney, conduct demographic marketing research, or seek declaratory rulings before discussing the most salient political issues of our day. Prolix laws which chill speech for the same reason that vague laws chill speech. People of common intelligence must necessarily guess at the law's meaning and differ as to its application. The government may not render a ban on political speech constitutional by carving out a limited exception through an amorphous regulatory interpretation. We must reject the approach suggested by the amici. Section 441b covers Hillary. Citizens United next argues that subsection 441b may not be applied to Hillary under the approach taken in WRTL. Wordle. McConnell decided that subsection 441b, subsection B2's definition of an electioneering communication was facially constitutional insofar as it restricted speech that was the functional equivalent of express advocacy for or against a specific candidate. Wordle then found an unconstitutional application of subsection 441b, where the speech was not express advocacy or its functional equivalent. As explained by the Chief Justice's controlling opinion in Wordle, the functional equivalent test is objective. A court should find that a communication is the functional equivalent of express advocacy only if it is susceptible of no reasonable interpretation other than as an appeal to vote for or against a specific candidate. Under this test, Hillary is equivalent to express advocacy. The movie, in essence, is a feature-length negative advertisement that urges viewers to vote against Senator Clinton for president. In light of historical footage, interviews with persons critical of her, and voiceover narration, the film would be understood by most viewers as an extended criticism of Senator Clinton's character and her fitness for the office of the presidency. The narrative may contain more suggestions and arguments than facts, but there is little doubt that the thesis of the film is that she is unfit for the presidency. The movie concentrates on alleged wrongdoing during the Clinton administration, Senator Clinton's qualifications and fitness for office, and policies the commentators predict she would pursue if elected president. It calls Senator Clinton Machiavellian and asks whether she is the most qualified to hit the ground running if elected president. The narrator reminds viewers that Americans have never been keen on dynasties, and that a vote for Hillary is a vote to continue 20 years of a Bush or a Clinton in the White House. Citizens United argues that Hillary is just a documentary film that examines certain historical events. We disagree. The movie's consistent emphasis is on the relevance of these events to Senator Clinton's candidacy for president. The narrator begins by asking, could Senator Clinton become the first female president in the history of the United States? And the narrator reiterates the movie's message in his closing line. Finally, before America decides on our next president, voters should need no reminders of what's at stake, the well-being and prosperity of our nation. The district court found there is no reasonable interpretation of Hillary other than as an appeal to vote against Senator Clinton. Under the standard contained in McConnell and further elaborated in Wordle, the film qualifies as the functional equivalent of express advocacy. Citizens United further contends that subsection 441b should be invalidated as applied to movies shown through video on demand, arguing that this delivery system has a lower risk of distorting the political process than do television ads. On what we might call conventional television, advertising spots reach viewers who have chosen a channel or a program for reasons unrelated to the advertising. With video on demand, by contrast, the viewer selects a program after taking a series of affirmative steps, subscribing to cable, navigating through various menus, and selecting the program. While some means of communication may be less effective than others, at influencing the public in different contexts, any effort by the judiciary to decide which means of communications are to be preferred for the particular type of message and speaker would raise questions as to the court's own lawful authority. Substantial questions would arise if courts were to begin saying what means of speech should be preferred or disfavored. And in all events, those differentiations might soon prove to be irrelevant or outdated by technologies that are in rapid flux. Courts, too, are bound by the First Amendment. We must decline to draw and then redraw constitutional lines based on the particular media or technology used to disseminate political speech from a particular speaker. It must be noted, moreover, that this undertaking would require substantial litigation over an extended time, all to interpret a law that beyond doubt discloses serious First Amendment flaws. The interpretive process itself would create an inevitable, pervasive, and serious risk of chilling protected speech, pending the drawing of fine distinctions that, in the end, would themselves be questionable. First Amendment standards, however, must give the benefit of any doubt to protecting rather than stifling speech. Citizens United also asks us to carve out an exception for subsection 441B's expenditure ban for nonprofit corporate political speech funded overwhelmingly by individuals. As an alternative to reconsidering Austin, the government also seems to prefer this approach. This line of analysis, however, would be unavailing. In MCFL, the court found unconstitutional subsection 441B's restrictions on corporate expenditures as applied to nonprofit corporations that were formed for the sole purpose of promoting political ideas, did not engage in business activities, and did not accept contributions from for-profit corporations or labor unions. BCRA's so-called Wellstone Amendment applied subsection 441B's expenditure ban to all nonprofit corporations. McConnell then interpreted the Wellstone Amendment to retain the MCFL exemption to subsection 441B's expenditure prohibition. Citizens United does not qualify for the MCFL exemption. However, since some funds used to make the movie were donations from for-profit corporations. The government suggests we could find BCRA's Wellstone Amendment unconstitutional, sever it from the statute, and hold that Citizens United speech is exempt from subsection 441B's ban under BCRA's Snow-Jeffords Amendment. The Snow-Jeffords Amendment operates as a backup provision that only takes effect if the Wellstone Amendment is invalidated. The Snow-Jeffords Amendment would exempt from subsection 441B's expenditure ban the political speech of certain nonprofit corporations if the speech were funded exclusively by individual donors and the funds were maintained in a segregated account. Citizens United would not qualify for the Snow-Jeffords exemption under its terms as written because Hillary was funded in part with donations from for-profit corporations. Consequently, to hold for Citizens United on this argument, the court would be required to revise the text of MCFL, sever BCRA's Wellstone Amendment, subsection 441BC6, and ignore the plain text of BCRA's Snow-Jeffords Amendment. If the court decided to create a de minimis exception to MCFL or the Snow-Jeffords Amendment, the result would be to allow for-profit corporate general treasury funds to be spent for independent expenditures that support candidates. There is no principled basis for doing this without rewriting Austin's holding that the government can restrict corporate independent expenditures for political speech. Though it is true that the court should construe statutes as necessary to avoid constitutional questions, the series of steps suggested would be difficult to take in view of the language of the statute. In addition to those difficulties, the government's suggestion is troubling for still another reason. The government does not say that it agrees with the interpretation it wants us to consider. Presumably, it would find textual difficulties in this approach. The government, like any party, can make arguments in the alternative, but it ought to say if there is merit to an alternative proposal instead of merely suggesting it. This is especially true in the context of the First Amendment. As the government stated, this case would require a remand to apply a de minimis standard. Applying this standard would thus require case-by-case determinations. But archetypical political speech would be chilled in the meantime. We decline to adopt an interpretation that requires intricate case-by-case determinations to verify whether political speech is banned, especially if we are convinced that, in the end, this corporation has a constitutional right to speak on this subject. As the foregoing analysis confirms, the court cannot resolve this case on a narrower ground without chilling political speech that is central to the meaning and purpose of the First Amendment. It is not judicial restraint to accept an unsound, narrow argument just so the court can avoid another argument in broader terms. Indeed, a court would be remiss in performing its duties were it to accept an unsound principle merely to avoid the necessity of making a broader ruling. Here, the lack of a valid basis for an alternative ruling requires full consideration of the continuing effect of the speech suppression upheld in Austin. Citizens United stipulated to dismissing Count 5 of its complaint, which raised a facial challenge to subsection 441B, even though Count 3 raised an as-applied challenge. The government argues that Citizens United waived its challenge to Austin by dismissing Count 5. We disagree. First, even if a party could somehow waive a facial challenge while preserving an as-applied challenge, that would not prevent the court from reconsidering Austin or addressing the facial validity of 441B in this case. Our practice permits review of an issue not pressed below so long as it has been passed upon. And here, the district court addressed Citizens United's facial challenge. In rejecting the claim, it noted that it would have to overrule McConnell for Citizens United to prevail on its facial challenge and that only the Supreme Court may overrule its decisions. The district court did not provide much analysis regarding the facial challenge because it could not ignore the controlling Supreme Court decisions in Austin and McConnell. Even so, the district court did pass upon the issue. Furthermore, the district court's later opinion, which granted the FEC's summary judgment, was based on the reasoning of its prior opinion, which included the discussion of the facial challenge. After the district court addressed the facial validity of the statute, Citizens United raised its challenge to Austin and in this court. In these circumstances, it is necessary to consider Citizens United's challenge to Austin and the facial validity of subsection 441B's expenditure ban. Second, throughout the litigation, Citizens United has asserted a claim that the FEC has violated its First Amendment right to free speech. All concede that this claim is properly before us. And once a federal claim is properly presented, a party can make any argument in support of that claim. Parties are not limited to the precise arguments they made below. Citizens United's argument that Austin should be overruled is not a new claim. Rather, it is, at most, a new argument to support what has been a consistent claim that the FEC did not accord Citizens United the rights it was obliged to provide by the First Amendment. Third, the distinction between facial and as-applied challenges is not so well defined that it has some automatic effect or that it must always control the pleadings and disposition in every case involving a constitutional challenge. The distinction is both instructive and necessary, for it goes to the breadth of the remedy employed by the court, not what must be pleaded in a complaint. The parties cannot enter into a stipulation that prevents the court from considering certain remedies if those remedies are necessary to resolve a claim that has been preserved. Citizens United has preserved its First Amendment challenge to subsections 441B as applied to the facts of its case. And given all the circumstances, we cannot easily address that issue without assuming a premise, the permissibility of restricting corporate political speech that is itself in doubt. As our request for supplemental briefing implied, Citizens United claim implicates the validity of Austin, which in turn implicates the facial validity of subsection 441B. When the statute now at issue came before the court in McConnell, both the majority and the dissenting opinions considered the question of its facial validity. The holding and validity of Austin were essential to the reasoning of the McConnell majority opinion, which upheld BCRA's extension of subsection 441B. McConnell permitted federal felony punishment for speech by all corporations that included nonprofit ones that speak on prohibited subjects shortly before federal elections. 4 members of the McConnell court would have overruled Austin, including Chief Justice Rehnquist, who had joined the court's opinion in Austin but reconsidered that conclusion. That inquiry into the facial validity of the statute was facilitated by the extensive record, which was over 100,000 pages long, made in the 3-judge district court. It is not the case, then, that the court today is premature in interpreting subsection 441B on the basis of a factually bare-bones record. The McConnell majority considered whether the statute was facially invalid. An as-applied challenge was brought in Wisconsin Right to Life Incorporated versus Federal Election Commission, and the court confirmed that the challenge could be maintained. Then, in Wordle, the controlling opinion of the court not only entertained an as-applied challenge but also sustained it. 3 justices noted that they would continue to maintain the position that the record in McConnell demonstrated the invalidity of the act on its face. The controlling opinion in Wordle, which refrained from holding the statute invalid except as applied to the facts then before the court, was a careful attempt to accept the essential elements of the court's opinion in McConnell while vindicating the First Amendment arguments made by the Wordle parties. As noted above, Citizens United's narrower arguments are not sustainable under a fair reading of the statute. In the exercise of its judicial responsibility, it is necessary then for the court to consider the facial validity of subsection 441B. Any other course of decision would prolong the substantial nationwide chilling effect caused by subsection 441B's prohibitions on corporate expenditures. Consideration of the facial validity of subsection 441B is further supported by the following reasons. First is the uncertainty caused by the litigation position of the government. As discussed above, see Part 2D. The government suggests as an alternative argument that an as-applied challenge might have merit. This argument proceeds on the premise that the nonprofit corporation involved here may have received only de minimis donations from for-profit corporations and that some nonprofit corporations may be exempted from the operation of the statute. The government also suggests that an as-applied challenge to subsection 441B's ban on books may be successful, although it would defend subsection 441B's ban as applied to almost every other form of media, including pamphlets. The government thus, by its own position, contributes to the uncertainty that subsection 441B causes. When the government holds out the possibility of ruling for Citizens United on a narrower ground yet refrains from adopting that position, the added uncertainty demonstrates the necessity to address the question of statutory validity. Second, substantial time would be required to bring clarity to the application of the statutory provision on these points, in order to avoid any chilling effect caused by some improper interpretation. It is well known that the public begins to concentrate on elections only in the weeks before they are held. There are short time frames in which speech can have influence. The need or relevance of the speech will often first be apparent at this stage in the campaign. The decision to speak is made in the heat of political campaigns when speakers react to messages conveyed by others. A speaker's ability to engage in political speech that could have a chance of persuading voters is stifled if the speaker must first commence a protracted lawsuit. By the time the lawsuit concludes, the election will be over and the litigants in most cases will have neither the incentive nor perhaps the resources to carry on, even if they could establish that the case is not moot because the issue is capable of repetition yet evading review. Here, Citizens United decided to litigate its case to the end. Today, Citizens United finally learns 2 years after the fact whether it could have spoken during the 2008 presidential primary, long after the opportunity to persuade primary voters has passed. Third is the primary importance of speech itself to the integrity of the election process. As additional rules are created for regulating political speech, any speech arguably within their reach is chilled. Campaign finance regulations now impose unique and complex rules on 71 distinct entities. These entities are subject to separate rules for 33 different types of political speech. The FEC has adopted 568 pages of regulations, 1,278 pages of explanations and justifications for those regulations, and 1,771 advisory opinions since 1975. In fact, after this court in Wordle adopted an objective appeal-to-vote test for determining whether a communication was the functional equivalent of express advocacy, the FEC adopted a 2-part, 11-factor balancing test to implement Wordle's ruling. This regulatory scheme may not be a prior restraint on speech in the strict sense of that term, for prospective speakers are not compelled by law to seek an advisory opinion from the FEC before the speech takes place. As a practical matter, however, given the complexity of the regulations and the deference courts show to administrative determinations, a speaker who wants to avoid threats of criminal liability and the heavy costs of defending against FEC enforcement must ask a governmental agency for prior permission to speak. These onerous restrictions thus function as the equivalent of prior restraint by giving the FEC power analogous to licensing laws implemented in the 16th and 17th century England, laws and government practices of the sorts that the First Amendment was drawn to prohibit. Because the FEC's business is to censor, there inheres the danger that it may well be less responsive than a court. Part of an independent branch of government to the constitutionally protected interests in free expression. When the FEC issues advisory opinions that prohibit speech, many persons, rather than undertake the considerable burden and sometimes risk of vindicating their rights through case-by-case litigation, will choose simply to abstain from protected speech, harming not only themselves but society as a whole, which is deprived of an uninhibited marketplace of ideas. Consequently, the censor's determination may in practice be final. This is precisely what Wordle sought to avoid. Wordle said that First Amendment standards must eschew the open-ended rough and tumble of factors, which invites complex arguments in a trial court and a virtually inevitable appeal. Yet the FEC has created a regime that allows it to select what political speech is safe for public consumption by applying ambiguous tests. If parties want to avoid litigation and the possibility of civil and criminal penalties, they must either refrain from speaking or ask the FEC to issue an advisory opinion approving of the political speech in question. Government officials pore over each word of the text to see if, in their judgment, it accords with the 11-factor test they have promulgated. This is an unprecedented governmental intervention into the realm of speech. The ongoing chill upon speech that is beyond all doubt protected makes it necessary in this case to invoke the earlier precedents that a statute which chills speech can and must be invalidated where its facial invalidity has been demonstrated. For these reasons, we find it necessary to reconsider Austin. The First Amendment provides that Congress shall make no law abridging the freedom of speech. Laws enacted to control or suppress speech may operate at different points in the speech process. The following are just a few examples of restrictions that have been attempted at different stages of the speech process. All laws found to be invalid. Restrictions requiring a permit at the outset. Imposing a burden by impounding proceeds on receipts or royalties. Seeking to exact a cost after the speech occurs, and subjecting the speaker to criminal penalties. The law before us is an outright ban, backed by criminal sanctions. Section 441B makes it a felony for all corporations, including nonprofit advocacy corporations, either to expressly advocate the election or defeat of candidates or to broadcast electioneering communications within 30 days of a primary election and 60 days of a general election. Thus, the following acts would be felonies under subsection 441B. The Sierra Club runs an ad within the crucial phase of 60 days before the general election that exhorts the public to disapprove of a congressman who favors logging in national forests. The National Rifle Association publishes a book urging the public to vote for the challenger because the incumbent U.S. Senator supports a handgun ban, and the American Civil Liberties Union creates a website telling the public to vote for a presidential candidate in light of that candidate's defense of free speech. These prohibitions are classic examples of censorship. Section 441B is a ban on corporate speech, notwithstanding the fact that a PAC created by a corporation can still speak. A PAC is a separate association from the corporation. The PAC exemption from subsection 441B's expenditure ban does not allow corporations to speak. Even if a PAC could somehow allow a corporation to speak, and it does not, the option to form PACs does not alleviate the First Amendment problems with subsection 441B. PACs are burdensome alternatives, they are expensive to administer and subject to extensive regulations. For example, every PAC must appoint a treasurer, forward donations to the treasurer promptly, keep detailed records of the identities of the persons making donations, preserve receipts for 3 years, and file an organization statement and report changes to this information within 10 days. And that is just the beginning. PACs must file detailed monthly reports with the FEC, which are due at different times depending on the type of election that is about to occur. These reports must contain information regarding the amount of cash on hand, the total amount of receipts detailed by 10 different categories, the identification of each political committee and candidates authorized or affiliated Committee making contributions, and any persons making loans, providing rebates, refunds, dividends, or interest, or any other offset to operate expenditures in an aggregate amount over $200. The total amount of all disbursements detailed by 12 different categories, the names of all authorized or affiliated committees to whom expenditures aggregating over $200 have been made, a person to whom loan repayment or refunds have been made, the total sum of all contributions, operating expenses, outstanding debts and obligations, and the settlement terms of the retirement of any debt or obligation. PACs have to comply with these regulations just to speak. This might explain why fewer than 2,000 of the millions of corporations in this country have PACs. PACs, furthermore, must exist before they can speak. Given the onerous restrictions, a corporation may not be able to establish a PAC in time to make its views known regarding candidates and issues in a current campaign. Section 441B's prohibition on corporate independent expenditures is thus a ban on speech, as a restriction on the amount of money a person or group can spend on political communication during a campaign. That statute necessarily reduces the quantity of expression by restricting the number of issues discussed, the depth of their exploration, and the size of the audience reached. Were the court to uphold these restrictions, the government could repress speech by silencing certain voices at any of the various points in the speech process. If subsection 441B applied to individuals, no one would believe that it is merely a time, place, or manner restriction on speech. Its purpose and effect are to silence entities whose voices the government deems to be suspect. Speech is an essential mechanism of democracy, for it is the means to hold officials accountable to the people. The right of citizens to inquire, to hear, to speak, and to use information to reach consensus is a precondition to enlighten self-government and a necessary means to protect it. The First Amendment has its fullest and most urgent application to speech uttered during a campaign for political office. For these reasons, political speech must prevail against laws that would suppress it, whether by design or inadvertence. Laws that burden political speech are subject to strict scrutiny, which requires the government to prove that the restriction furthers a compelling interest and is narrowly tailored to achieve that interest. While it might be maintained that political speech simply cannot be banned or restricted as a categorical manner, the quoted language from Wordle provides a sufficient framework for protecting the relevant First Amendment interests in this case. We shall employ it here. Premised on mistrust of governmental power, the First Amendment stands against attempts to disfavor certain subjects or viewpoints. Prohibited too are restrictions distinguishing among different speakers, allowing speech by some but not others. As instruments to censor, these categories are interrelated. Speech restrictions based on the identity of the speaker are all too often simply a means to control content. Quite apart from the purpose or effect of regulating content, moreover, the government may commit a constitutional wrong when by law it identifies certain preferred speakers. By taking the right to speak from some and giving it to others, the government deprives the disadvantaged person or class of the right to use speech to strive to establish worth. Standing, and respect for the speaker's voice. The government may not, by these means, deprive the public of the right and privilege to determine for itself what speech and speakers are worthy of consideration. The First Amendment protects speech and speaker, and the ideas that flow from each. The court has upheld a narrow class of speech restrictions that operate to the disadvantage of certain persons, but these rulings were based on an interest in allowing governmental entities to perform their functions. The corporate independent expenditures at issue in this case, however, would not interfere with governmental functions. So these cases are inopposite. These precedents stand only for the proposition that there are certain governmental functions that cannot operate without some restrictions on particular kinds of speech. By contrast, it is inherent in the nature of the political process that voters must be free to obtain information from diverse sources in order to determine how to cast their votes. At least before Austin, the court had not allowed the exclusion of a class of speakers from the general public dialogue. We find no basis for the proposition that in the context of political speech, the government may impose restrictions on certain disfavored speakers. Both history and logic lead us to this conclusion. The court has recognized that First Amendment protection extends to corporations. This protection has been extended by explicit holdings to the context of political speech. Under the rationale of these precedents, political speech does not lose First Amendment protection simply because its source is a corporation. The court has thus rejected the argument that political speech of corporations or other associations should be treated differently under the First Amendment simply because such associations are not natural persons. At least since the latter part of the 19th century, the laws of some states and of the United States imposed a ban on corporate direct contributions to candidates. Yet not until 1947 did Congress first prohibit independent expenditures by corporations and labor unions under subsection 304 of the Labor Management Relations Act of 1947. In passing this act, Congress overrode the veto of President Truman, who warned that the expenditure ban was a dangerous intrusion on free speech. For almost 3 decades thereafter, the court did not reach the question whether restrictions on corporate and union expenditures are constitutional. The question was in the background of United States versus CIO. There, a labor union endorsed a congressional candidate in its weekly periodical. The court stated that the gravest doubt would arise in our minds as to the federal expenditure prohibition's constitutionality if it were construed to suppress that writing. The court engaged in statutory interpretation and found that the statute did not cover the publication. 4 justices, however, said that they would reach the constitutional question and invalidate the Labor Management Relations Act expenditure ban. The concurrence explained that any undue influence generated by a speaker's large expenditures was outweighed by the loss for democratic processes resulting from the restrictions upon free and full public discussions. In United States versus Automobile Workers, the court again encountered the independent expenditure ban, which had been recodified as 18 U.S.C. subsection 610. After holding only that a union television broadcast that endorsed candidates was covered by the statute, the court refused to anticipate constitutional questions and remanded for the trial to proceed. 3 justices dissented, arguing that the court should have reached the constitutional question and that the ban on independent expenditures was unconstitutional. Under our Constitution, it is we the people who are sovereign. The people have the final say. The legislatures are their spokesmen. The people determine through their votes the destiny of the nation. It is therefore vitally important, that all channels of communication be open to them during every election, that no point of view be restrained or barred, and that the people have access to the views of every group in the community. The dissent concluded that deeming a particular group too powerful was not a justification for withholding First Amendment rights from any group, labor, or corporate. The court did not get another opportunity to consider the constitutional question in that case, for after a remand, a jury found the defendants not guilty. Later, in Pipefitters v. United States, the court reversed a conviction for expenditure of union funds for political speech, again without reaching the constitutional question. The court would not resolve that question for another 4 years. In Buckley, the court addressed various challenges to the Federal Election Campaign Act of 1971 as amended in 1974. These amendments created 18 U.S.C. subsection 608E, an independent expenditure ban separate from subsection 610 that applied to individuals as well as corporations and labor unions. Before addressing the constitutionality of subsection 608E's independent expenditure ban, Buckley first upheld subsection 608B, FECA's limits on direct contributions to candidates. The Buckley Court recognized a sufficiently important governmental interest in the prevention of corruption and the appearance of corruption. This followed from the court's concern that large contributions could be given to secure a political quid pro quo. The Buckley Court explained that the potential for quid pro quo corruption distinguished direct contributions to candidates from independent expenditures. The court emphasized that the independent expenditure ceiling fails to serve any substantial governmental interest in stemming the reality or appearance of corruption in the electoral process, because the absence of prearrangement and coordination alleviates the danger that expenditures will be given a quid pro quo for improper commitments from the candidate. Buckley invalidated subsection 608E's restrictions on independent expenditures, with only 1 justice dissenting. Buckley did not consider subsection 610's separate ban on corporate and union independent expenditures. The prohibition that had also been in the background in CIO, automobile workers and pipe fitters. Had subsection 610 been challenged in the wake of Buckley, however, it could not have been squared with the reasoning and analysis of that precedent. The expenditure ban invalidated in Buckley applied to corporations and unions, and some of the prevailing plaintiffs in Buckley were corporations. The Buckley court did not invoke the First Amendment's overbreadth doctrine to suggest that subsection 608E's expenditure ban would have been constitutional if it had applied only to corporations and not to individuals. Buckley cited with approval the automobiles workers' dissent, which argued that subsection 610 was unconstitutional. Notwithstanding this precedent, Congress recodified subsection 610's corporate and union expenditure ban at 2 U.S.C. subsection 441B 4 months after Buckley was decided. Section 441B is the independent expenditure restriction challenged here. Less than 2 years after Buckley, Bellotti reaffirmed the First Amendment principle that the government cannot restrict political speech based on the speaker's corporate identity. Bellotti could not have been clearer when it struck down a state law prohibition on corporate independent expenditures related to referenda issues. We thus find no support in the First Amendment or in the decisions of this court for the proposition that speech that otherwise would be within the protection of the First Amendment loses that protection simply because its source is a corporation that cannot prove to the satisfaction of the court a material effect on its business or property. That proposition amounts to an impermissible legislative prohibition of speech based on the identity of the interest that spokesmen may represent in public debate over controversial issues, and a requirement that the speaker have a sufficiently great interest in the subject to justify communication. In the realm of protected speech, the legislature is constitutionally disqualified from dictating the subjects about which persons may speak and the speakers who may address a public issue. It is important to note that the reasoning and holding of Bellotti did not rest on the existence of a viewpoint discriminatory statute. It rested on the principle that the government lacks the power to ban corporations from speaking. Bellotti did not address the constitutionality of the state's ban on corporate independent expenditures to support candidates. In our view, however, that restriction would have been unconstitutional under Bellotti's central principle that the First Amendment does not allow political speech restrictions based on the speaker's corporate identity. Thus, the law stood until Austin. Austin upheld a direct restriction on the independent expenditures of funds for political speech for the first time in this court's history. The Michigan Chamber of Commerce sought to use general treasury funds to run a newspaper ad supporting a specific candidate. Michigan law, however, prohibits corporate independent expenditures that supported or opposed any candidate for state office. A violation of the law was punishable as a felony. The court sustained the speech prohibition. To bypass Buckley and Bellotti, the Austin court identified a new governmental interest in limiting political speech, an anti-distortion interest. Austin found a compelling governmental interest in preventing the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public's support for the corporation's political ideas. The court is thus confronted with conflicting lines of precedent, a pre-Austin line that forbids restrictions on political speech based on the speaker's corporate identity, and a post-Austin line that permits them. No case before Austin had held that Congress could prohibit independent expenditures for political speech based on the speaker's corporate identity. Before Austin, Congress had enacted legislation for this purpose, and the government urged the same proposition before this court. In neither of these cases did the court adopt the proposition. In its defense of the corporate speech restrictions in subsection 441B, the government notes the anti-distortion rationale on which Austin and its progeny rest in part. Let me just check that I didn't skip over anything. Nope. In its defense, the corporate speech restrictions in subsection 441B, the government notes the anti-distortion rationale on which Austin and its progeny rest in part, yet it all but abandons reliance upon it. It argues instead that two other compelling interests support Austin's holding that corporate expenditure restrictions are constitutional: an anti-corruption interest and a shareholder protection interest. We consider the 3 points in turn. 3, I thought it said 2. It argues that there are two compelling. Okay. As for Austin's anti-distortion rationale, the government does little to defend it, and with good reason, for the rationale cannot cannot support subsection 441B. If the First Amendment has any force, it prohibits Congress from fining or jailing citizens or associations of citizens for simply engaging in political speech. If the anti-distortion rationale were to be accepted, however, it would permit government to ban political speech simply because the speaker is an association that has taken on the corporate form. The government contends that Austin permits it to ban corporate expenditures for almost all forms of communication stemming from a corporation. If Austin were correct, the government could prohibit a corporation from expressing political views in media beyond those presented here, such as by printing books. The government responds that the FEC has never applied this statute to a book, and if it did, there would be quite a good as applied challenge. This troubling assertion of brooding governmental power cannot be reconciled with the confidence and stability in civic discourse that the First Amendment must secure. Political speech is indispensable to decision-making in a democracy, and this is no less true because the speech comes from a corporation rather than an individual. This protection for speech is inconsistent with Austin's anti-distortion rationale. Austin sought to defend the anti-distortion rationale as a means to prevent corporations from obtaining an unfair advantage in the political marketplace by using resources amassed in the economic marketplace. But Buckley rejected the premise that the government has an interest in equalizing the relative ability of individuals and groups to influence the outcome of elections. Buckley was specific in stating that the skyrocketing cost of political campaigns could not sustain the government's prohibition. The First Amendment's protections did not depend on the speaker's financial ability to engage in public discussion. The court reaffirmed these conclusions when it invalidated the BCRA provision that increased the cap on contributions to one candidate if the opponent made certain expenditures from personal funds. The rule that political speech cannot be limited based on a speaker's wealth is a necessary consequence of the premise that the First Amendment generally prohibits the suppression of political speech based on the speaker's identity. Either as support for its anti-distortion rationale or as a further argument, the Austin majority undertook to distinguish wealthy individuals from corporations on the ground that state laws grants corporations special advantages, such as limited liability, perpetual life, and favorable treatment of the accumulation and distribution of assets. This does not suffice, however, to allow laws prohibiting speech. It is rudimentary that the state cannot exact as the price of those special advantages the forfeiture of First Amendment rights. It is irrelevant for purposes of the First Amendment that corporate funds may have little or no correlation to the public support for the corporation's political ideas. All speakers, including individuals and the media, use money amassed from the economic marketplace to fund their speech. The First Amendment protects the resulting speech even if it was enabled by economic transactions with persons or entities who disagree with the speaker's ideas. Austin's anti-distortion rationale would produce the dangerous and unacceptable consequence that Congress could ban political speech of media corporations. Media corporations are now exempt from subsection 441B's ban on corporate expenditures. Yet media corporations accumulate wealth with the help of the corporate form. The largest media corporations have immense aggregations of wealth, and the views expressed by media corporations often have little or no correlation to the public's support for those views. Thus, under the government's reasoning, wealthy media corporations could have their voices diminished to put them on par with other media entities. There is no precedent for permitting this under the First Amendment. The media exemption discloses further difficulties with the law now under consideration. There is no precedent supporting laws that attempt to distinguish between corporations which are deemed to be exempt as media corporations and those which are not. We have consistently rejected the proposition that the institutional press has any constitutional privilege beyond that of other speakers. With the advent of the internet and the decline of print and broadcast media, moreover, the line between the media and others who wish to comment on political and social issues becomes far more blurred. The law's exemption for media corporations is, on its own terms, all but an admission of the invalidity of the anti-distortion rationale, and the exemption results in a further separate reason for finding this law invalid. Again, by its own terms, the law exempts some corporations but covers others, even though both have the need or the motive to communicate their views. The exemption applies to media corporations owned or controlled by corporations that have diverse and substantial investments and participate in endeavors other than news. So even assuming the most doubtful proposition that a news organization has a right to speak when others do not, the exemption would allow a conglomerate that owns both a media business and an unrelated business to influence or control the media in order to advance its overall business interest. At the same time, some other corporation with an identical business interest but no media outlet in its ownership structure would be forbidden to speak or inform the public about the same issue. This differential treatment cannot be squared with the First Amendment. There is simply no support for the view that the First Amendment, as originally understood, would permit the suppression of political speech by media corporations. The framers may not have anticipated modern business and media corporations, yet television networks and major newspapers owned by media corporations have become the most important means of mass communication in modern times. The First Amendment was certainly not understood to condone the suppression of political speech in society's most salient media. It was understood as a response to the repression of speech and the press that had existed in England and the heavy taxes on the press that were imposed in the colonies. The great debates between the Federalists and the Anti-Federalists over our founding document were published and expressed in the most important means of mass communication of that era, newspapers owned by individuals. At the founding, speech was open, comprehensive, and vital to society's definition of itself. There were no limits on the sources of speech and knowledge. The framers may have been unaware of certain types of speakers or forms of communication, but that does not mean that those speakers and media are entitled to less First Amendment protection than those types of speakers and media that provide the means of communicating political ideas when the Bill of Rights was adopted. Austin interferes with the open marketplace of ideas protected by the First Amendment. It permits the government to ban the political speech of millions of associations of citizens. Most of these are small corporations without large amounts of wealth. This fact belies the government's argument that the statute is justified on the ground that it prevents the distorting effects of immense aggregations of wealth. Let me make sure I didn't skip anything. Oh, I did. Where was I? Austin interferes with the open marketplace of ideas protected by the First Amendment. It permits the government to ban political speech of millions of associations of citizens. Most of these are small corporations without large amounts of wealth. This fact belies the government's argument that the statute is justified on the ground that it prevents the distorting effects of immense aggregations of wealth. It is not even aimed at amassed wealth. The censorship we now confront is vast in its reach. The government has muffled the voices that best represent the most significant segments of the economy, and the electorate has been deprived of information, knowledge, and opinion vital to its function. By suppressing the speech of manifold corporations, both for-profit and non-profit, the government prevents their voices and viewpoints from reaching the public and advising voters on which persons or entities are hostile to their interests. Factions will necessarily form in our republic, but the remedy of destroying the liberty of some factions is worse than the disease. Factions should be checked by permitting them all to speak, and by entrusting the people to judge what is true and what is false. The purpose and effect of this law is to prevent corporations, including small and nonprofit corporations, from presenting both facts and opinions to the people. This makes Austin's anti-distortion rationale all the more an aberration. The First Amendment protects the rights of corporations to petition legislative and administrative bodies, quoting Bellotti. Corporate executives and employees counsel members of Congress and presidential administrations on many issues as a matter of routine and often in private. An amici brief filed on behalf of Montana and 25 other states notes that lobbying and corporate communications with elected officials occur on a regular basis. When that phenomenon is coupled with subsection 441B, the result is that smaller or nonprofit corporations cannot raise a voice to object when other corporations, including those with vast wealth, are cooperating with the government. That cooperation may sometimes be voluntary, or it may be the demand of a government official who uses his or her authority, influence, and power to threaten corporations to support the government's policies. Those kinds of interactions are often unknown and unseen. The speech that subsection 441B forbids, though, is public, and all can judge its content and purpose. References to massive corporate treasuries should not mask the real operation of this law. Rhetoric ought not obscure reality. Even if subsection 441B's expenditure ban were constitutional, wealthy corporations could still lobby elected officials, although smaller corporations may not have the resources to do so. And wealthy individuals and unincorporated associations can spend unlimited amounts of money on independent expenditures. Yet certain disfavored associations of citizens, those that have taken on the corporate form, are penalized for engaging in the same political speech. When a government seeks to use its full power, including the criminal law, to command where a person may get his or her information or what distrusted source he or she may not hear, it uses censorship to control thought. This is unlawful. The First Amendment confirms the freedom to think for ourselves. What we have said also shows the invalidity of other arguments made by the government. For the most part, relinquishing the anti-distortion rationale, the government falls back on the argument that corporate political speech can be banned in order to prevent corruption or its appearance. In Buckley, the court found this interest sufficiently important to allow limits on contributions, but did not extend that reasoning to independent expenditures. When Buckley examined an expenditure ban, it found that the governmental interest in preventing corruption and the appearance of corruption was inadequate to justify the ban on independent expenditures. With regard to large direct contributions, Buckley reasoned that they could be given to secure a political quid pro quo, and that the scope of such pernicious practices can never be reliably ascertained. The practices, Buckley noted, would be covered by bribery laws if a quid pro quo arrangement were proved. The court, in consequence, has noted that restrictions on direct contributions are preventative because few, if any, contributions to candidates will involve quid pro quo arrangements. The Buckley court, nevertheless, sustained limits on direct contributions in order to ensure against the reality or appearance of corruption. That case did not extend this rationale to independent expenditures, and the court does not do so here. The absence of pre-arrangement and coordination of an expenditure with the candidate or his agent not only undermines the value of the expenditure to the candidate, but also alleviates the danger that expenditures will be given as a quid pro quo for improper commitments from the candidate. Limits on independent expenditures, such as subsection 441B, have a chilling effect extending well beyond the government's interest in preventing quid pro quo corruption. The anti-corruption interest is not sufficient to displace the speech here in question. Indeed, 26 states do not restrict independent expenditures by for-profit corporations. The government does not claim that these expenditures have corrupted the political process in those states. A single footnote in Bilotti purported to leave open the possibility that corporate independent expenditures could be shown to cause corruption. For the reasons explained above, we now conclude that independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption. Dicta in Bilotti's footnote suggested that a corporation's right to speak on issues of general public interest implies no comparable right in the quite different context of participation in a political campaign for election to public office. Citing the portion of Buckley that invalidated the federal independent expenditure ban and a law review student comment, Bilotti surmised that Congress might well be able to demonstrate the existence of a danger of real or apparent corruption in independent expenditures by corporations to influence candidate elections. Buckley, however, struck down a ban on independent expenditures to support candidates that covered corporations, and explained that the distinction between discussion of issues and candidates and advocacy of election or defeat of candidates may often dissolve in practical application. Bilotti's dictum is thus supported only by a law review student comment which misinterpreted Buckley. Seizing on this aside in Bilotti's footnote, the court in NRWC did say there is a sufficient governmental interest in ensuring that substantial aggregations of wealth amassed by corporations would not be used to incur political debts from legislatures who are aided by the contributions. NWRC, however, has little relevance here. NWRC decided no more than that a restriction on a corporation's ability to solicit funds for its segregated PAC, which made direct contributions to candidates, did not violate the First Amendment. NWRC thus involved contribution limits, which, unlike limits on independent expenditures, have been an accepted means to prevent quid pro quo corruption. Citizens United has not made direct contributions to candidates, and it has not suggested that the court should reconsider whether contribution limits should be subjected to rigorous First Amendment scrutiny. When Buckley identified a sufficiently important governmental interest in preventing corruption or the appearance of corruption, that interest was limited to quid pro quo corruption. The fact that speakers may have influence over access to elected officials does not mean that these officials are corrupt. Favoritism and influence are not avoidable in representative politics. It is in the nature of an elected representative to favor certain policies and, by necessary corollary, to favor the voters and contributors who support those policies. It is well understood that a substantial and legitimate reason, if not the only reason, to cast a vote for or to make a contribution to one candidate over another is that the candidate will respond by producing those political outcomes that the supporter favors. Democracy is premised on responsiveness. Reliance on a generic favoritism or influence theory is at odds with standard First Amendment analyses because it is unbounded and susceptible to no limiting principle. The appearance of influence or access, furthermore, will not cause the electorate to lose faith in our democracy. By definition, an independent expenditure is political speech presented to the electorate that is not coordinated with a candidate. The fact that a corporation or any other speaker is willing to spend money to try to persuade voters presupposes that the people have the ultimate influence over elected officials. That is inconsistent with any suggestion that the electorate will refuse to take part in democratic governance because of additional political speech made by a corporation or any other speaker. Caperton versus A.T. Masley Coal Company is not to the contrary. Caperton held that a judge was required to recuse himself when a person with a personal stake in a particular case had a significant and disproportionate influence in placing the judge on the case by raising funds or directing the judge's election campaign when the case was pending or imminent. The remedy of recusal was based on a litigant's due process right to a fair trial before an unbiased judge. Caperton's holding was limited to the rule that the judge must be recused, not that the litigant's political speech could be banned. The McConnell's record was over 100,000 pages long, yet it does not have any direct examples of votes being exchanged for expenditures. This confirms Buckley's reasoning that independent expenditures do not lead to or create the appearance of quid pro quo corruption. In fact, there is only scant evidence that independent expenditures even ingratiate. Ingratiation and access, in any event, are not corruption. The BCRA record establishes that certain donations to political parties, called soft money, were made to gain access to elected officials. This case, however, is about independent expenditures, not soft money. When Congress finds that a problem exists, we must give that finding due deference. But Congress may not choose an unconstitutional remedy. If elected officials succumb to improper influences from independent expenditures, if they surrender their best judgment, and if they put expediency before principle, then surely there is cause for concern. We must give weight to attempts by Congress to seek to dispel either the appearance or the reality of these influences. The remedies enacted by law, however, must comply with the First Amendment, and it is our law and our tradition that more speech, not less, is the governing rule. An outright ban on corporate political speech during the critical pre-election period is not a permissible remedy. Here, Congress has enacted categorical bans on speech that are asymmetrical to preventing quid pro quo corruption. The government contends further that corporate independent expenditures can be limited because of its interest in protecting dissenting shareholders from being compelled to fund corporate political speech. This asserted interest, like Austin's anti-distortion rationale, would allow the government to ban the political speech even of media corporations. Assume, for example, that a shareholder of a corporation that owns a newspaper disagrees with the political views the newspaper expresses. Under the government's view, that potential disagreement could give the government the authority to restrict the media corporation's political speech. The First Amendment does not allow that power. There is furthermore little evidence of abuse that cannot be corrected by shareholders through the procedures of corporate democracy. Those reasons are sufficient to reject this shareholder protection interest, and moreover, the statute is both under-inclusive and over-inclusive. As to the first, if Congress had been seeking to protect dissenting shareholders, it would not have banned corporate speech in only certain media within 30 or 60 days before an election. A dissenting shareholder's interests would be implicated by speech in any media at any time. And as to the second, the statute is over-inclusive because it covers all corporations, including nonprofit corporations and for-profit corporations with only single shareholders. As to other corporations, the remedy is not to restrict speech, but to consider and explore other regulatory mechanisms. The regulatory mechanism here, based on speech, contravenes the First Amendment. We need not reach the question whether the government has a compelling interest in preventing foreign individuals or associations from influencing our nation's political process. Section 441B is not limited to corporations or associations that were created in foreign countries or funded predominantly by foreign shareholders. Section 441B, therefore, would be overbroad even if we assume arguendo that the government has a compelling interest in limiting foreign influence over our political process. Our precedent is to be respected unless the most convincing of reasons demonstrates that adherence to it puts us on a course that is sure error. Beyond workability, the relevant factors in deciding whether to adhere to the principle of stare decisis include the antiquity of the precedent, the reliance interests at stake, and of course whether the decision was well reasoned. We have also examined whether experience has pointed out the precedent's shortcomings. These considerations counsel in favor of rejecting Austin, which itself contravened this court's earlier precedents in Buckley and Bellotti. This court has not hesitated to overrule decisions offensive to the First Amendment. Stare decisis is a principle of policy and not a mechanical formula of adherence to the latest decision. For the reasons above, it must be concluded that Austin was not well reasoned. The government defends Austin relying almost entirely on the quid pro quo interest, the corruption interest, or the shareholder interest, and not Austin's expressed anti-distortion rationale. When neither party defends the reasoning of a precedent, the principle of adhering to that precedent through stare decisis is diminished. Austin abandoned First Amendment principles, furthermore, by relying on language in some of our precedents that traces back to the Automobile Workers Court's flawed historical account of campaign finance laws. Austin is undermined by experience since its announcement. Political speech is so ingrained in our culture that speakers find ways... Oh, let me check that I didn't skip anything. Automobile Workers fine too. Nope. Austin is undermined by experience since its announcement. Political speech is so ingrained in our culture that speakers find ways to circumvent campaign finance laws. Our nation's speech dynamic is changing, and informative voices should not have to circumvent onerous restrictions to exercise their First Amendment rights. Speakers have become adept at presenting citizens with soundbites, talking points, and scripted messages that dominate the 24-hour news cycle. Corporations, like individuals, do not have monolithic views. On certain topics, corporations may pose valuable expertise, leaving them the best equipped to point out errors or fallacies in speech of all sorts, including the speech of candidates and elected officials. Rapid changes in technology and the creative dynamic inherent in the concept of free expression counsel against upholding a law that restricts political speech in certain media or by certain speakers. Today, 30-second television ads may be the most effective way to convey a political message. Soon, however, it may be that internet sources, such as blogs and social networking websites, will provide citizens with significant information about political candidates and issues. Yet subsection 441B would seem to ban a blog post expressly advocating the election or defeat of a candidate if that blog were created with corporate funds. The First Amendment does not permit Congress to make these categorical distinctions based on the corporate identity of the speaker and the content of the speech, of the political speech. No serious reliance interests are at stake. As the court restated in Payne v. Tennessee, this reliance interests are important considerations in property and contract cases where parties have acted in conformance with existing legal rules in order to conduct transactions. Here, though, parties have been prevented from acting. Corporations have been banned from making independent expenditures. Legislatures may have enacted bans on corporate expenditures, believing that those bans were constitutional. This is not a compelling interest for stare decisis. If it were, legislative acts could prevent us from overruling our own precedents, thereby interfering with our duty to say what the law is. Due consideration leads to this conclusion. Due considerations lead to this conclusion. Austin should be and now is overruled. We return to the principle established in Buckley and Bellotti that the government may not suppress political speech on the basis of the speaker's corporate identity. No sufficient governmental interest justifies limits on the political speech of nonprofit or for-profit corporations. Austin is overruled, so it provides no basis for allowing the government to limit corporate independent expenditures. As the government appears to concede, overruling Austin's effectively invalidates not only BCRA's subsection 20, section 203, but also 2 USC 441B's prohibition on the use of corporate treasury funds for express advocacy. Section 441B's restrictions on corporate independent expenditures are therefore invalid and cannot be applied to Hillary. Given our conclusion, we are further required to overrule the part of McConnell that upheld BCRA's subsection 203's extension of section 441B's restrictions on corporate independent expenditures. The McConnell court relied on the anti-distortion interest in recognizing in Austin to uphold a greater restriction on speech than the restriction upheld in Austin, and we have found this interest unconvincing and insufficient. This part of McConnell is now overruled. Citizens United next challenges BCRA's disclaimer and disclosure provisions as applied to Hillary and the 3 advertisements for the movie. Under BCRA subsection 311, televised electioneering communications funded by anyone other than a candidate must include a disclaimer that blank is responsible for the content of this advertising. The required statement must be made in a clearly spoken manner and displayed on the screen in a clearly readable manner for at least 4 seconds. It must state that the communication is not authorized by any candidate or candidate's committee. It must also display the name and address or website address of the person or group that funded the advertisement. Under BCRA subsection 201, any person who spends more than $10,000 on electioneering communications within a calendar year must file a disclosure statement with the FEC. That statement must identify the person making the expenditure, the amount of the expenditure, the election to which the communication was directed, and the names of certain contributors. Disclaimer and disclosure requirements may burden the ability to speak, but they impose no ceiling on campaign-related activities and do not prevent anyone from speaking. The court has subjected these requirements to exacting scrutiny, which requires a substantial relation between the disclosure requirement and a sufficiently important governmental interest. In Buckley, the court explained that disclosure could be justified based on a governmental interest in providing the electorate with information about the sources of election-related spending. The McConnell court applied this interest in rejecting facial challenges to BCRA subsections 201 and 311. There was evidence in the record that independent groups were running election-related advertisements, while hiding behind dubious and misleading names. The court therefore upheld BCRA subsections 201 and 311 on the ground that they would help citizens make informed choices in the political marketplace. Although both provisions were facially upheld, the court acknowledged that as-applied challenges would be available if a group could show a reasonable probability that disclosure of its contributors' names will subject them to threats, harassment, or reprisals from either government officials or private parties. For the reasons stated below, we find the statute valid as applied to the ads for the movie and to the movie itself. Citizens United sought to broadcast only 1 30-second and 2 10-second ads to promote Hillary. Under FEC regulations, a communication that proposes a commercial transaction was not subject to 2 USC subsection 441B's restriction on corporate or union funding of electioneering communications. The regulations, however, do not exempt those communications from the disclaimer and disclosure requirements in BCRA subsections 201 and 311. Citizens United argues that the disclaimer requirements in subsection 311 are unconstitutional as applied to its ads. It contends that the governmental interest in providing information to the electorate does not justify requiring disclaimers for any commercial advertisements, including the ones at issue here. We disagree. The ads fall within BCRA's definition of an electioneering communication. They are referred to then Senator Clinton by name shortly before a primary and contain pejorative references to her candidacy. The disclaimers required by subsection 311 provided the electorate with information and ensure that the voters are fully informed about the person or group who is speaking. At the very least, the disclaimers avoid confusion by making it clear that the ads are not funded by a candidate or political party. Citizens United argues that subsection 311 is underinclusive because it requires disclaimers for broadcast advertisements but not for print or internet advertising. It asserts that subsection 311 decreases both the quantity and effectiveness of the group's speech by forcing it to devote 4 seconds of each advertisement to the spoken disclaimer. We rejected these arguments in McConnell, and we now adhere to that decision as it pertains to the disclosure provisions. As a final point, Citizens United claims that, in any event, the disclosure requirements in subsection 201 must be confined to speech that is the functional equivalent of express advocacy. The principal opinion in Wordle limited restrictions on independent expenditures to express advocacy and its functional equivalent. Citizens United seeks to import a similar distinction in BCRA's disclosure requirements. We reject this contention. The court has explained that disclosure is a less restrictive alternative to more comprehensive regulations of speech. In Buckley, the court upheld a disclosure requirement for independent expenditures even though it invalidated a provision that imposed a ceiling on those expenditures. In McConnell, 3 justices who would have found subsection 441B to be unconstitutional nonetheless voted to uphold BCRA's disclosure and disclaimer requirements. And the court has upheld registration and disclosure requirements on lobbyists, even though Congress has no power to ban lobbying itself. For these reasons, we reject Citizens United's contention that the disclosure requirement must be limited to speech that is the functional equivalent of express advocacy. Citizens United also disputes that an informational interest justifies the application of subsection 201 to its ads, which only attempt to persuade viewers to see the film. Even if it disclosed the funding sources for the ads, Citizens United says the information would not help viewers make informed choices in the political marketplace. This is similar to the argument rejected above with respect to disclaimers. Even if the ads only pertain to a commercial transaction, the public has an interest in knowing who is speaking about a candidate shortly before an election. Because the informational interest alone is sufficient to justify application of subsection 201 to these ads, it is not necessary to consider the government's other asserted interests. Last, Citizens United argues that disclosure requirements can chill donations to an organization by exposing donors to retaliation. Some amici point to recent events in which donors to certain causes were blacklisted, threatened, or otherwise targeted for retaliation. In McConnell, the court recognized that subsection 201 would be unconstitutional, as applied to an organization if there were a reasonable probability that the group's members would face threats, harassment, or reprisals if their names were disclosed. The examples cited by amici are cause for concern. Citizens United, however, has offered no evidence that its members may face similar threats or reprisals. To the contrary, Citizens United has been disclosing its donors for years and has identified no instance of harassment or retaliation. Shareholder rejection raised through the procedures of corporate democracy and can be more effective today because modern technology makes disclosures rapid and informative. A campaign finance system that pairs corporate independent expenditures with effective disclosure has not existed before today. It must be noted, furthermore, that many of Congress's findings in passing BCRA were premised on a system without adequate disclosure. With the advent of the internet, prompt disclosure of expenditures can provide shareholders and citizens with the information needed to hold corporations and elected officials accountable for their positions and supporters. Shareholders can determine whether their corporation's political speech advances the corporation's interest in making profits, and citizens can see whether elected officials are in the pocket of so-called moneyed interests. The First Amendment protects political speech, and disclosure permits citizens and shareholders to react to the speech of corporate entities in a proper way. This transparency enables the electorate to make informed decisions and give proper weight to different speakers and messages. For the same reason, we uphold the application of BCRA subsections 201 and 311 to the ads. We affirm their application to Hillary. We find no constitutional impediment to the application of BCRA's disclaimer and disclosure requirements to a movie broadcast via video on demand. And there has been no showing that, as applied in this case, these requirements would impose a chill on speech or expression. When word concerning the plot of the movie Mr. Smith Goes to Washington reached the circles of government, some officials sought by persuasion to discourage its distribution. Under Austin, though, officials could have done more than discourage its distribution. They could have banned the film. After all, it, like Hillary, was speech funded by a corporation that was critical of members of Congress. Mr. Smith Goes to Washington may be fiction and caricature, but fiction and caricature can be a powerful force. Modern-day movies, television comedies, or skits on YouTube.com, might portray public officials or public policies in unflattering ways. Yet if a covered transmission during the blackout period creates the background for candidate endorsement or opposition, a felony occurs solely because a corporation other than an exempt media corporation has made the purchase, payment, distribution, loan, advance, deposit, or gift of money or anything of value in order to engage in political speech. Speech would be suppressed in the realm where its necessity is most evident, in the public dialogue preceding a real election. Governments are often hostile to speech, but under our law and our tradition, it seems stranger than fiction for our government to make this political speech a crime. Yet this is the statute's purpose and design. Some members of the public might consider Hillary to be insightful and instructive. Some might find it to be neither high art nor a fair discussion on how to set the nation's course. Still others simply might suspend judgment on these points but decide to think more about issues and candidates. Those choices and assessments, however, are not for the government to make. The First Amendment underwrites the freedom to experiment and to create in the realm of thought and speech. Citizens must be free to use new forms and new forums for the expression of ideas. The civic discourse belongs to the people, and the government may not prescribe the means used to conduct it. The judgment of the district court is reversed with respect to the constitutionality of 2 U.S.C. subsection 441b's restrictions on corporate independent expenditures. The judgment is affirmed with respect to BCRA's disclaimer and disclosure requirements. The case is remanded for further proceedings consistent with this opinion. Chief Justice Roberts, with whom Justice Alito joins concurring. The government urges us in this case to uphold a direct prohibition on political speech. It asks us to embrace a theory of the First Amendment that would allow censorship not only of television and radio broadcasts, but of pamphlets, posters, the internet, and virtually any other medium that corporations and unions might find useful in expressing their views on matters of public concern. In its theory, if accepted, would empower the government to prohibit newspapers from running editorials or opinion pieces supporting or opposing candidates for office so long as the newspapers were owned by corporations, as the major ones are. First Amendment rights could be confined to individuals, subverting the vibrant public discourse that is at the foundation of our democracy. The court properly rejects that theory, and I join its opinion in full. The First Amendment protects more than just the individual on a soapbox and the lonely pamphleteer. I write separately to address the important principles of judicial restraint and stare decisis implicated in this case. Judging the constitutionality of an act of Congress is the gravest and most delicate duty that this court is called on to perform. Because the stakes are so high, our standard practice is to refrain from addressing constitutional questions except when necessary to rule on particular claims before us. This policy underlies both our willingness to construe ambiguous statutes to avoid constitutional problems and our practice never to formulate a rule of constitutional law broader than is required by the precise facts to which it is to be applied. The majority and dissent are united in expressing allegiance to these principles. But I cannot agree with my dissenting colleagues on how these principles apply in this case. The majority's step-by-step analysis accords with our standard practice of avoiding broad constitutional questions except when necessary to decide the case before us. The majority begins by addressing, and quite properly rejecting, Citizens United's statutory claim that 2 U.S.C. subsection 441b does not actually cover its production and distribution of Hillary the movie, hereinafter Hillary. If there were a valid basis for deciding this statutory claim in Citizens United's favor and thereby avoiding constitutional adjudication, it would be proper to do so. Indeed, that is precisely the approach the court took just last term in Northwest Austin Municipal Utility District No. 1 versus Holder, when 8 members of the court agreed to decide the case on statutory grounds instead of reaching the appellant's broader argument that the Voting Rights Act is unconstitutional. It is only because the majority rejects Citizens United's statutory claim that it proceeds to consider the group's various constitutional arguments, beginning with the narrowest claim that Hillary is not the functional equivalent of express advocacy, and proceeding to its broadest claim that Austin versus Michigan Chamber of Commerce should be overruled. This is the same order of operations followed by the controlling opinion in Federal Election Commission versus Wisconsin Right to Life, Wordle. There the appellant was able to prevail on the narrowest constitutional argument because its broadcast ads did not qualify as the functional equivalent of express advocacy. There was thus no need to go on to address the broader claim that McConnell versus Federal Elections Commission should be overruled. This case is different, not as the dissent suggests, because the approach taken in Wisconsin in Wordle has been deemed a failure, but because, in the absence of any valid narrower ground of decision, there is no way to avoid Citizens United's broader constitutional argument. The dissent advocates an approach to Citizens United's claims that I find quite perplexing. It presumably agrees with the majority that Citizens United's narrower statutory and constitutional arguments lack merit. Otherwise, its conclusion that the group should lose this case would make no sense. Despite agreeing that these narrower arguments fail, however, the dissent argues that the majority should nonetheless latch on to one of them in order to avoid reaching the broader constitutional question of whether Austin remains good law. It even suggests that the court's failure to adopt one of these concededly meritless arguments is a sign that the majority is not serious about judicial restraint. This approach is based on a false premise, that our practice of avoiding unnecessary and unnecessarily broad constitutional holdings somehow trumps our obligation to faithfully to interpret the law. It should go without saying, however, that we cannot embrace a narrow ground of decision simply because it is narrow. It must also be right. Thus, while it is true that if it is not necessary to decide more, it is necessary not to decide more. Sometimes it is necessary to decide more. There is a difference between judicial restraint and judicial abdication. When constitutional questions are indispensably necessary to resolve the case at hand, the court must meet and decide them. Because it is necessary to reach Citizens United's broader argument that Austin should be overruled, the debate over whether to consider this claim on an as-applied or facial basis strikes me as largely beside the point. Citizens United has standing. It is being injured by the government's enforcement of the act. Citizens United has a constitutional claim. The act violates the First Amendment because it prohibits political speech. The government has a defense. The act may be enforced consistent with the First Amendment against corporations. Whether the claim or the defense prevails is the question before us. Given the nature of that claim and defense, it makes no difference of any substance whether this case is resolved by invalidating the statute on its face or only as applied to Citizens United. Even if considered in as-applied terms, a holding in this case that the act may not be applied to Citizens United because corporations as well as individuals enjoy the pertinent First Amendment rights would mean that any other corporation raising the same challenge would also win. Likewise, a conclusion that the act may be applied to Citizens United because it is constitutional to prohibit corporate political speech would similarly govern future cases. Regardless whether we label Citizens United's claim as facial or as applied challenge, the consequences of the court's decision are the same. The text and purpose of the First Amendment point in the same direction. Congress may not prohibit political speech even if the speaker is a corporation or union. What makes this case difficult is the need to confront our prior decision in Austin. This is the first case in which we have been asked to overrule Austin, and thus it is also the first in which we have had reason to consider how much weight to give stare decisis in assessing its continued validity. The dissent erroneously declares that the court reaffirmed Austin's holding in subsequent cases, namely Federal Election Commission versus Beaumont, and Wordle. Not so. Not a single party in any of those cases asked us to overrule Austin, and as the dissent points out, the court generally does not consider constitutional arguments that have not properly been raised. Austin's validity was therefore not directly at issue in the case the dissent cites. The court's unwillingness to overturn Austin in those cases cannot be understood as a reaffirmation of that decision. Fidelity to precedent, the policy of stare decisis is vital to the proper exercise of the judicial function. Stare decisis is the preferred course because it promotes the even-handed, predictable, and consistent development of legal principles, fosters reliance on judicial decisions, and contributes to the actual and perceived integrity of the judicial process. For these reasons, we have long recognized that departures from precedent are inapposite in the absence of a special justification. At the time, stare decisis is neither an inexorable command nor a mechanical formula of adherence to the latest decision, especially in constitutional cases, see United States versus Scott. Even if it were, segregation would be legal, minimum wage laws would be unconstitutional, and the government could wiretap ordinary criminal suspects without first obtaining warrants. As the dissent properly notes, none of us has viewed stare decisis in such absolute terms. Stare decisis is instead a principle of policy. When considering whether to re-examine a prior erroneous holding, we must balance the importance of having constitutional questions decided against the importance of having them decided right. As Justice Jackson explained, this requires a sober appraisal of the disadvantages of the innovation as well as those of the questioned case, a weighing of practical effects of one against another. In conducting this balancing, we must keep in mind that stare decisis is not an end in itself. It is instead the means by which we ensure that the law will not merely change erratically, but will develop in a principled and intelligible fashion. Its greatest purpose is to serve a constitutional ideal, the rule of law. It follows that in the unusual circumstance when fidelity to any particular precedent does more to damage this constitutional ideal than to advance it, we must be more willing to depart from that precedent. Thus, for example, if the precedent under consideration itself departed from the court's jurisprudence, returning to the intrinsically sounder doctrine established in prior cases may better serve the values of stare decisis than would following the more recently decided case inconsistent with the decisions that came before it. Abrogating the errant precedent rather than reaffirming or extending it might better preserve the law's coherence and curtail the precedent's disruptive effects. Likewise, if adherence to a precedent actually impedes the stable and orderly adjudication of future cases, its stare decisis effect is also diminished. This can happen in a number of circumstances, such as when the precedent's validity is so hotly contested that it cannot reliably function as a basis for decision in future cases, when its rationale threatens to upend our settled jurisprudence in related areas of law, and when the precedent's underlying reasoning has become so discredited that the court cannot keep the precedent alive without jury-rigging new and different justifications to shore up the original mistake. These considerations weigh against retaining our decision in Austin. First, as the majority explains, that decision was an aberration insofar as it departed from the robust protections we had granted political speech in our earlier cases. Austin undermined the careful line that Buckley drew to distinguish limits on contributions to candidates from limits on independent expenditures on speech. Buckley rejected the asserted government interest in regulating independent expenditures, concluding that restricting the speech of some elements of our society in order to enhance the relative voices of others is wholly foreign to the First Amendment. Austin, however, allowed the government to prohibit these same expenditures out of concern for the corrosive and distorting effects of immense aggregations of wealth in the marketplace of ideas. Austin's reasoning was, and remains, inconsistent with Buckley's explicit repudiation of any government interest in equalizing the relative ability of individuals and groups to influence the outcome of elections. Austin was also inconsistent with Bellatti's clear rejection of the idea that speech that otherwise would be within the protection of the First Amendment loses that protection simply because its source is a corporation. The dissent correctly points out that Bellatti involved a referendum rather than a candidate election, but that Bellatti itself noted this factual distinction. But this distinction does not explain why corporations may be subject to prohibitions on speech in candidate elections when individuals may not. Second, the validity of Austin's rationale, itself adopted over two spirited dissents, has proved to be the consistent subject of dispute among members of this court ever since. The simple fact that one of our decisions remains controversial is, of course, insufficient to justify overruling it, but it does undermine the president's ability to contribute to the stable and orderly development of the law. In such circumstances, it is entirely inappropriate for the court, which in this case is squarely asked to reconsider Austin's validity for the first time, to address the matter with a greater willingness to consider new approaches capable of restoring our doctrine to sounder footing. Third, the Austin decision is uniquely destabilizing because it threatens to subvert our court's decisions even outside the particular context of corporate express advocacy. The First Amendment theory underlying Austin's holding is extraordinarily broad. Austin's logic would allow government prohibition of political speech by a category of speakers in the name of equality, a point that most scholars acknowledge and many celebrate, but that the dissent denies. It should not be surprising, then, that members of the court have relied on Austin's expansive logic to justify greater incursions on the First Amendment, even outside the original context of corporate advocacy on behalf of candidates running for office. The dissent in this case succumbs to the same temptation. Suggestion that Austin justifies prohibiting corporate speech because such speech might unduly influence the marketplace for legislation. The dissent reads Austin to permit restrictions on corporate speech based on nothing more than the fact that the corporate form may help individuals coordinate and present their views more effectively. A speaker's ability to persuade, however, provides no basis for government regulation of free and open public debate on what the laws should be. If taken seriously, Austin's logic would apply most directly to newspapers and other media corporations. They have a more profound impact on public discourse than most other speakers. These corporate entities are, for the time being, not subject to subsection 441B's otherwise generally applicable prohibitions on corporate political speech. But this is simply a matter of legislative grace. The fact that the law currently grants a favored position to media corporations is no reason to overlook the danger inherent in accepting a theory that would allow government restrictions on their political speech. These readings of Austin do no more than carry that decision's reasoning to its logical endpoint. In doing so, they highlight the threat Austin poses to First Amendment rights generally, even outside its specific factual context of corporate express advocacy, because Austin is so difficult to confine to its facts, and because its logic threatens to undermine our First Amendment jurisprudence and the nature of public discourse more broadly. The costs of giving it stare decisis effect are unusually high. Finally, and most importantly, the government's own effort to defend Austin, or more accurately, to defend something that is not quite Austin, underscores its weakness as a precedent of this court. The government concedes that Austin is not the most lucid opinion, yet asks us to reaffirm its holding. But while invoking stare decisis to support this position, the government never once even mentions the compelling interest that Austin relied upon in the first place, the need to diminish the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little to no correlation with the public's support for the corporation's political ideas. Instead of endorsing Austin on its own terms, the government urges us to reaffirm Austin's specific holding on the basis of two new and potentially expansive interests: the need to prevent actual or apparent quid pro quo corruption and the need to protect corporate shareholders. Those interests may or may not support the result in Austin, but they were plainly not part of the reasoning on which Austin relied. To its credit, the government forthrightly concedes that Austin did not embrace either of the new rationales it now urges upon us. In other words, you are asking... this is from the transcript. To be clear, the court in Austin nowhere relied upon the only arguments the government now raises to support that decision. In fact, the only opinion in Austin endorsing the government's argument based on the threat of quid pro quo corruption was Justice Stevens' concurrence. The court itself did not do so, despite the fact that the concurrence highlighted the argument. Moreover, the court's only discussion of shareholder protection in Austin appeared in a section of the opinion that sought merely to distinguish Austin's facts from those of Federal Election Commission versus Massachusetts Citizens for Life, Incorporated. Nowhere did Austin suggest that the goal of protecting shareholders is itself a compelling interest authorizing restrictions on First Amendment rights. To the extent that the government's case for reaffirming Austin depends on radically reconceptualizing its reasoning, that argument is at odds with itself. Stare decisis is a doctrine of preservation, not transformation. It counsels deference to past mistakes, but provides no justification for making new ones. There is therefore no basis for the court to give precedential sway to reasoning that it has never accepted simply because that reasoning happens to support a conclusion reached on different grounds that have since been abandoned or discredited. Doing so would undermine the rule of law values that justify stare decisis in the first place. It would effectively license the court to invent and adopt new principles of constitutional law solely for the purpose of rationalizing its past errors, without a proper analysis of whether those principles have merit on their own. This approach would allow the court's past missteps to spawn future mistakes, undercutting the very rule of law values that stare decisis is designed to protect. None of this is to say that the government is barred from making new arguments to support the outcome in Austin. On the contrary, it is free to do so, and of course the court is free to accept them. But the government's new arguments must stand or fall on their own. They are not entitled to receive the special deference we accord to precedent. They are, as grounds to support Austin, literally unprecedented. Moreover, to the extent the government relies on new arguments and declines to defend Austin on its own terms, we may reasonably infer that it lacks confidence in that decision's original justification. Because continued adherence to Austin threatens to subvert the principled and intelligible development of our First Amendment jurisprudence, I support the court's determination to overrule that decision. We have had 2 rounds of briefing in this case, 2 oral arguments, and 54 amicus briefs to help us carry out our obligation to decide the necessary constitutional questions according to law. We have also had the benefit of a comprehensive dissent that has helped ensure that the court has considered all the relevant issues. This careful consideration convinces me that Congress violated the First Amendment when it decrees that some speakers may not engage in political speech at election time when it matters most. Justice Scalia, with whom Justice Alito joins, and with whom Justice Thomas joins in part concurring, I join the opinion of the court. I write separately to address Justice Stevens' discussion of original understandings. This section of the dissent purports to show that today's decision is not supported by the original understanding of the First Amendment. The dissent attempts this demonstration, however, in splendid isolation from the text of the First Amendment. It never shows why the freedom of speech that was the right of Englishmen did not include the freedom to speak in association with other individuals, including associations in the corporate forum. To be sure, in 1791 and now, corporations could pursue only the objectives set forth in their charters, but the dissent provides no evidence that their speech in the pursuit of those objectives could be censored. Instead of taking this straightforward approach to determining the amendment's meaning, the dissent embarks on detailed explorations of the framers' views about the role of corporations in society. The framers did not like corporations, the dissent concludes, and therefore it follows as night the day that corporations had no rights of free speech. Of course, the framers' personal affection or disaffection for corporations is relevant only insofar as it can be thought to be reflected in the understood meaning of the text they enacted, not, as the dissent suggests, as a freestanding substitute for that text. But the dissent's distortion of proper analysis is even worse than that. Though faced with a constitutional text that makes no distinction between types of speakers, the dissent feels no necessity to provide even an isolated statement from the founding era to the effect that corporations are not covered, but places the burden on appellate to bring forward statements showing that they are. Despite the corporation-hating quotations the dissent has dredged up, it is far from clear that by the end of the 18th century, corporations were despised. If so, how came there so to be many of them? The dissent's statement that there were few business corporations during the 18th century, only a few hundred during all of the 18th century, is misleading. There were approximately 335 charters issued to business corporations in the United States by the end of the 18th century. This was a considerable extension of corporate enterprise in the field of business, and represented unprecedented growth. Moreover, what seems like a small number by today's standards surely does not indicate the relative importance of corporations when the nation was considerably smaller. As I have previously noted, by the end of the 18th century, the corporation was a familiar figure in American economic life. Even if we thought it proper to apply the dissent's approach to excluding the First Amendment coverage what the founders disliked, and even if we agreed that the founders disliked founding-era corporations, modern corporations might not qualify for exclusion. Most of the founders' resentment towards corporations was directed at the state-granted monopoly privileges that individually chartered corporations enjoyed. Modern corporations do not have such privileges and would probably have been favored by most of our enterprising founders, excluding perhaps Thomas Jefferson and others favoring perpetuation of an agrarian society. Moreover, if the founders' specific intent with respect to corporations is what matters, why does the dissent ignore the founders' views about other legal entities that have more in common with modern business corporations than the founding era corporations? At the time of the founding, religious, educational, and literary corporations were incorporated under general incorporation statutes, much as business corporations are today. There were also small unincorporated business associations, which some have argued were the true progenitors of today's business corporations. Were all of these silently excluded from the protections of the First Amendment? The lack of a textual exception for speech by corporations cannot be explained on the ground that such organizations did not exist or did not speak. To the contrary, colleges, towns, and cities, religious institutions, and guilds had long been organized as corporations at common law and under the King's Charter. I have discussed and and, as I have discussed, the practice of incorporation only expanded in the United States. Both corporations and voluntary associations actively petitioned the government and expressed their views in newspapers and pamphlets. For example, an anti-slavery Quaker corporation petitioned the first Congress, distributed pamphlets, and communicated through the press in 1790. The New York Sons of Liberty sent a circular of colonies farther south. This is just quoting stuff. The dissent offers no evidence, none whatsoever, that the First Amendment's unqualified text was originally understood to exclude associational speech from its protection. Historical evidence relating to the textually similar clause, the freedom of the press, also provides no support for the proposition that the First Amendment excludes conduct of artificial legal entities from the scope of its protection. The freedom of the press was widely understood to protect the publishing activities of individual editors and printers. But these individuals often acted through newspapers, which, much like corporations, had their own names, outlived the individuals who had founded them, could be bought and sold, were sometimes owned by more than one person, and were operated for profit. Their activities were not stripped of First Amendment protection simply because they were carried out under the banner of an artificial legal entity. And the notion which follows from the dissent's view that modern newspapers, since they are incorporated, have free speech rights only at the sufferance of Congress boggles the mind. In passing, the dissent also claims that the court's conception of corruption is unhistorical. The framers would have been appalled, it says, by the evidence of corruption in the congressional findings supported by the Bipartisan Campaign Reform Act. For this proposition, the dissent cites a law review article arguing that corruption was originally understood to include moral decay and even actions taken by citizens in pursuit of private rather than public ends. It is hard to see how this has anything to do with what sort of corruption can be combated by restrictions on political speech. Moreover, if speech can be prohibited because, in the view of the government, it leads to moral decay or does not serve public ends, then there is no limit to the government's censorship power. The dissent says that when the framers constitutionalized the right to free speech in the First Amendment, it was the free speech of individual Americans that they had in mind. That is no doubt true. All the provisions of the Bill of Rights set forth the rights of individual men and women, not, for example, of trees or polar bears. But the individual person's right to speak includes the right to speak in association with other individual persons. Surely the dissent does not believe that speech by the Republican Party or the Democratic Party can be censored because it is not speech of an individual American. It is the speech of many individual Americans who have associated in a common cause, giving the leadership of the party the right to speak on their behalf. The association of individuals in a business corporation is no different, or at least it cannot be denied the right to speak on the simplistic ground that it is not an individual American. But to return to and summarize my principal point, which is the conformity of today's opinion with the original meaning of the First Amendment, the amendment is written in terms of speech, not speakers. Its text offers no foothold for excluding any category of speaker, from single individuals to partnerships of individuals to unincorporated associations of individuals to incorporated associations of individuals, and the dissent offers no evidence about the original meaning of the text to support any such exclusion. We are therefore simply left with the question whether the speech at issue in this case is speech covered by the First Amendment. No one says otherwise. A documentary film critical of a potential presidential candidate is core political speech, and its nature as such does not change simply because it was funded by a corporation. Nor does the character of that funding produce any reduction whatsoever in the inherent worth of the speech and its capacity for informing the public. Indeed, to exclude or impede corporate speech is to muzzle the principal agents of the modern free economy. We should celebrate rather than condemn the addition of this speech to the public debate. Justice Stevens, with whom Justice Ginsburg, Justice Breyer, and Justice Sotomayor join, concurring in part and dissenting in part. The real issue in this case concerns how, not if, the appellant may finance its electioneering. Citizens United is a wealthy nonprofit corporation that runs a political action committee, PAC, with millions of dollars in assets. Under the Bipartisan Campaign Reform Act of 2002, BCRA, it could have used those assets to televise and promote Hillary, the movie, wherever and whenever it wanted to. It also could have spent unrestricted sums to broadcast Hillary at any time other than the 30 days before the last primary election. Neither Citizens Citizens United nor any other corporation's speech has been banned. All that the parties dispute is whether Citizens United had a right to use the funds in its general treasury to pay for broadcasts during the 30-day period. The notion that the First Amendment dictates an affirmative answer to that question is, in my judgment, profoundly misguided. Even more misguided is the notion that the court must rewrite the law relating to campaign expenditures by for-profit corporations and unions to decide this case. The basic premise underlying the court's ruling is its iteration and constant reiteration of the proposition that the First Amendment bars regulatory distinctions based on the speaker's identity, including its identity as a corporation. While that glittering generality has rhetorical appeal, it is not a correct statement of law, nor does it tell us when a corporation may engage in electioneering that some of its shareholders oppose. It does not even resolve the specific question whether Citizens United may be required to finance some of its messaging with the money in its PAC. The conceit that corporations must be treated identically to natural persons in the political sphere is not only inaccurate but also inadequate to justify the court's disposition of this case. In the context of election to public office, the distinction between corporate and public speakers is significant. Although they make enormous contributions to our society, corporations are not actually members of it. They cannot vote or run for office. Because they may be managed and controlled by non-residents, their interests may conflict in fundamental respects with the interests of eligible voters. The financial resources, legal structure, and instrumental orientation of corporations raise legitimate concerns about their role in the electoral process. Our lawmakers have a compelling constitutional basis, if not also a democratic duty, to take measures designed to guard against the potentially deleterious effects of corporate spending in local and national races. The majority's approach to corporate electioneering marks a dramatic break from our past. Congress has placed special limitations on campaign spending by corporations ever since the passage of the Tillman Act in 1907. We have unanimously concluded that this reflects a permissible assessment of the dangers posed by those entities to the electoral process, and have accepted the legislative judgment that the special characteristics of the corporate structure require particularly careful regulation. The court today rejects a century of history when it treats the distinction between corporate and individual campaign spending as an invidious novelty born of Austin versus Michigan Chamber of Commerce. Relying largely on individual dissenting opinions, the majority blazes through our precedents, overruling or disavowing a body of law that includes FEC versus Wisconsin Right to Life, Wordle, McConnell versus FEC, Beaumont, FEC versus Beaumont, FEC versus Massachusetts Citizens for Life Incorporated, and California Medical Association versus FEC. In his landmark concurrence in Ashwater versus TVA, Justice Brandeis stressed the importance of adhering to rules the court has developed for its own governance when deciding constitutional questions. Because departures from those rules always enhance the risk of error, I shall review the background of this case in some detail before explaining why the court's analysis rests on a faulty understanding of Austin and McConnell and of our campaign finance jurisprudence more generally. I regret the length of what follows, but the importance and novelty of the court's opinion require a full response. Although I concur in the court's decision to sustain BCRA's disclosure provisions and join Part 4 of its opinion, I emphatically dissent from its principal holding. The court's ruling threatens to undermine the integrity of elected institutions across the nation. The path it has taken to reach its outcomes I fear, do damage to this institution. Before turning to the question whether to overrule Austin and part of McConnell, it is important to explain why the court should not be deciding that question. The scope of the case. The first reason is that the question was not properly before us. In declaring subsection 203 of BCRA facially unconstitutional on the ground that corporations' electoral expenditures may not be regulated any more stringently than those of individuals, the majority decides this case on a basis relinquished below, not included in the questions presented to us by the litigants, and argued here only in response to the court's invitation. This procedure is unusual and inadvisable for a court. Our colleague suggests that we are asked to reconsider Austin and, in effect, McConnell. Would be more accurate if rephrased to state that we have asked ourselves to reconsider those cases. In the district court, Citizens United initially raised a facial challenge to the constitutionality of subsection 203. In its motion for summary judgment, however, Citizens United expressly abandoned its facial challenge. The district court, therefore, resolved the case on alternative grounds, and in its in its jurisdictional statement to this court, Citizens United properly advised us that it was raising only an as-applied challenge to the constitutionality of BCRA subsection 203. The jurisdictional statement never so much as cited Austin, the key case the majority today overrules, and not one of the questions presented suggested that Citizens United was surreptitiously raising a facial challenge to subsection 203 that it previously agreed to dismiss. In fact, not one of those questions raised an issue based on Citizens United corporate status. Moreover, even in its merits briefing, when Citizens United injected its request to overrule Austin, it never sought a declaration that subsection 203 was facially unconstitutional, as to all corporations and unions. Instead, it argued that the statute could not be applied to it because it was funded overwhelmingly by individuals. The appellant in this case did not so much as assert an exceptional circumstance, and one searches the majority opinion in vain for the mention of any. That is unsurprising, for none exist. Setting the case for re-argument was a constructive step, but it did not cure this fundamental problem. Essentially, 5 justices were unhappy with the limited nature of the case before us, so they changed the case to give themselves an opportunity to change the law. This court has repeatedly emphasized in recent years that facial challenges are disfavored. By declaring subsection 203 facially unconstitutional, our colleagues have turned an as-applied challenge into a facial challenge in defiance of this principle. This is not merely a technical defect in the court's decision. The unnecessary resort to a facial inquiry runs contrary to the fundamental principle of judicial restraint that courts should neither anticipate a question of constitutional law in advance of the necessity of deciding it, nor formulate a rule of constitutional law broader than is required by the precise facts to which it is to be applied. Scanting that principle threatens to short-circuit the democratic process by preventing laws embodying the will of the people from being implemented in a manner consistent with the Constitution. These concerns are heightened when judges overrule settled doctrine upon which the legislature has relied. The court operates with a sledgehammer rather than a scalpel when it strikes down one of Congress's most significant efforts to regulate the rule that corporations The court also operates with a sledgehammer rather than a scalpel when it strikes down one of Congress's most significant efforts to regulate the role that corporations and unions play in electoral politics. And it compounds the offense by implicitly striking down a great many state laws as well. The problem goes still deeper, for the court does all of this on the basis of pure speculation. Had Citizens United maintained a facial challenge and thus argued that there are virtually no circumstances in which BCRA subsection 203 can be applied constitutionally, the parties could have developed through the normal process of litigation a record about the actual effects of subsection 203, its actual burdens, and its actual benefits on all manners of corporations and unions. Claims of facial invalidity often rest on speculation and consequently raise the risk of premature interpretation of statutes on the basis of factually bare-bones records. In this case, the record is not simply incomplete or unsatisfactory, it is non-existent. Congress crafted BCRA in response to a virtual mountain of research on the corruption that previous legislation had failed to avert. The court now negates Congress's efforts without a shred of evidence on how subsection 203 or its state law counterparts have been affecting any entity other than Citizens United. Faced with this gaping empirical hole, the majority throws up its hands. Were we to confine our inquiry to Citizens United's as-applied challenge, it protests, we would commence an extended amount of drawing and then redrawing constitutional lines based on the particular media or technology used to disseminate political speech from a particular speaker. While tacitly acknowledging that some applications of subsection 203 might be found constitutional, the majority thus posits a future in which novel First Amendment standards must be devised on an ad hoc basis and then leaps from this unfounded prediction to the unfounded conclusion that such complexity counsels the abandonment of all normal restraint. Yet it is a pervasive feature of regulatory systems that unanticipated events, such as new technologies, may raise some unanticipated difficulties at the margins. The fluid nature of electioneering communications does not make this case special. The fact that a court can hypothesize situations in which a statute might, at some point down the line, pose some unforeseen as-applied problems does not come close to meeting the standard for a facial challenge. The majority proposes several other justifications for the sweep of its ruling. It suggests that a facial ruling is necessary because if the court were to continue on its normal course of resolving as-applied challenges as they present themselves, that process would itself run afoul of the First Amendment. This suggestion is perplexing. Our colleagues elsewhere trumpet our duty to say what the law is, even when our predecessors on the bench and our counterparts in Congress have interpreted the law differently. We do not typically say what the law is not as a hedge against future judicial error. The possibility that later courts will misapply a constitutional provision does not give us a basis for pretermitting litigation relating to that provision. The majority suggests that a facial ruling is necessary because anything less would chill too much protected speech. In addition to begging the question what types of corporate spending are constitutionally protected and to what extent, this claim rests on the assertion that some significant number of corporations have been cowed into quiescence by FEC censorship. That assertion is unsubstantiated, and it is hard to square with practical experience. It is particularly hard to square with the legal landscape following Wordle, which held that a corporate communication could be regulated under subsection 203 only if it was susceptible of no reasonable interpretation other than an appeal to vote for or against a specific candidate. The whole point of this test was to make subsection 203 as simple and speech protective as possible. The court does not explain how, in the span of a single election cycle, it has determined the Chief Justice's project to be a failure. In this respect, the majority's critique of line drawing collapses into a critique of the as-applied review method generally. The majority suggests that even though it expressly dismissed its facial challenge, Citizens United nevertheless preserved it, not as a freestanding claim, but as a potential argument in support of a claim that the FEC has violated its First Amendment right to free speech. By this novel logic, virtually any submission could be reconceptualized as a claim that the government has violated my rights, and it would then be available to the court to entertain any conceivable issue that might be relevant to that claim's disposition. Not only the as-applied facial distinction, but the basic relationship between litigants and courts would be upended if the latter had free rein to construe the former's claim at such high levels of generality. There would be no need for plaintiffs to argue their case. They could just cite the constitutional provisions they think relevant and leave the rest to us. Finally, the majority suggests that though the scope of Citizens United's claim may be narrow, a facial ruling is necessary as a matter of remedy. Relying on a law review article, it asserts that Citizens United's dismissal of the facial challenge does not prevent us from making broader pronouncements of invalidity in properly as-applied cases. The majority is on firmer conceptual ground here. Yet even if one accepts this part of Professor Fallon's thesis, one must proceed to ask which as-applied challenges, if successful, will properly invite or entail invalidation of the underlying statute. The paradigmatic case is a judicial determination that the legislature acted with an impermissible purpose in enacting a provision, as this carries the necessary implication that all future as-applied challenges to the provision must prevail. Citizens United as-applied challenge was not of this sort. Until this court ordered re-argument, its contention was that BCRA subsection 203 could not lawfully be applied to a feature-length video-on-demand film, such as Hillary, or to a non-profit corporation exempt from taxation under 26 U.S.C. subsection 501c4, and funded overwhelmingly by individuals, such as itself. Success on either of these claims would not necessarily carry any implications for the validity of subsection 203 as applied to other types of broadcast. Other types of corporations or unions. It certainly would not invalidate the statute as applied to a large for-profit corporation. There is no legitimate basis for resurrecting a facial challenge that dropped out of this case 20 months ago. Narrower grounds. It is all the more distressing that our colleagues have manufactured a facial challenge because the parties have advanced numerous ways to resolve the case that would facilitate electioneering by nonprofit advocacy corporations such as Citizens United without toppling statutes and precedents, which is to say the majority has transgressed yet another cardinal principle of the judicial process. If it is not necessary to decide more, it is necessary not to decide more. Consider just three of the narrower grounds of decision that the majority has bypassed. First, the court could have ruled on statutory grounds that a feature-length film distributed through video on demand does not qualify as an electioneering communication under subsection 203 of BCRA. BCRA defines the term to encompass certain communications transmitted by broadcast, cable, or satellite. When Congress was developing BCRA, the video-on-demand medium was still in its infancy, and legislatures were focused on a very different sort of programming, short advertisements run on television or radio. The sponsors of BCRA acknowledged that the FEC's implementing regulations do not clearly apply to video-on-demand transmissions. In light of this ambiguity, the distinctive characteristics of video on demand, and the elementary rule that every reasonable construction must be resorted to in order to save a statute from unconstitutionality, the court could have reasonably ruled that subsection 203 does not apply to Hillary. Second, the court could have expanded the MCFL exemption to cover subsection 50C4 nonprofits that accept only a de minimis amount of money from for-profit corporations. Citizens United professes to be such a group. Its brief says it is funded predominantly by donations from individuals who support its ideological message. Numerous courts of appeals have held that de minimis business support does not in itself remove an otherwise qualifying organization from the ambit of MCFL. This court could have simply followed their lead. Finally, let us not forget Citizens United as applied constitutional challenge. Precisely because Citizens United looks so much like the MCFL organizations we have exempted from regulation, while a feature-length video-on-demand film looks so unlike the types of electoral advocacy Congress has found deserving of regulation. This challenge is a substantial one. As the appellate's own arguments show, the court could have easily limited the breadth of its constitutional holding had it declined to adopt the novel notion that speakers and speech acts must always be treated identically, and always spared expenditures restrictions in the political realm. Yet the court nonetheless turns its back on the as-applied review process that has been a staple of campaign finance litigation since Buckley versus Vallejo. This brief tour of alternative grounds on which the case could have been decided is not meant to show that any of these grounds is ideal, though each is perfectly valid. It is meant to show that there were principled narrower paths that a court that was serious about judicial restraint could have taken. There was also the straightforward path, applying Austin and McConnell just as the district court did in holding that the funding of Citizens United's film can be regulated under them. The only thing preventing the majority from affirming the district court or adopting a narrower ground that would retain Austin is its disdain for Austin. Okay, so we'll stop for part one there. And as always, if there's any case you'd like me to read, just drop in the comments and happy to take a look. And I will be out with part two shortly. Thank you.